Alright, so hello everybody. We're going to be watching some grounds from Brooks, the dude's something else. And yeah, okay, so yeah, hello Richard and hello Mermaid. She said today not so good now. Oh. Well, I'll say, Mermaid, that I really am enjoying the gaming videos you're doing very much. I mean, which later I've been watching the one you released last night. I'm going to be commenting on it, at some point later. But it is. Oh, it scared you, Duke? Scared? Yeah, scared. So, basically, yeah. So, Mermaid, if you, and by the way, hope everybody has a good Holy Week, or those that don't celebrate this, Holy Week, Happy Holidays. And yeah, Mermaid, if you want to say any updates about anything, I am here, or if you just want to watch and listen to the court stuff or what we're playing, that is fine too. So thank you for being here, everybody. And yeah, we'll be doing this. So certainly it is I'm glad this dude was locked up, because he definitely was his own worst enemy, but he's one of the most bizarre trials that have occurred in the trial histories. Alright, so be going over and playing it right now. And here we go.
Back on the record, then appearances are as they were before. State have their next witness available.
Yes, Your Honor.
All right, let's bring the jury back out.
I don't consent to being called by the name that this court chooses to identify me by. I want to state for the record that I'm here as a third-party intervener on special appearance on behalf of my client.
But yeah, yes, understood, Mermaid. Thank you for letting me know. Yeah, life does do that, and it's like it goes through cycles, and it's kind of like a bicycle wheel. It'll go around and around, and but definitely those amusement. It's so cool they made amusement parks out of those games that you're playing. Just for the record, that it was like like slides. It's like actually being on like the water slides. So I think that was very cool, and your channel has grown very much. So I am proud of you for that. And so, as I said, I believe things over time will get better. But thank you for being here. We appreciate you very much.
Can that be noted for the record?
It was noted this morning.
May it be noted again for the record, so that we can keep the record clear and accurate.
The appearances are as they were this morning. They are no different. Bring the jury up.
And we have yet to address subject matter jurisdiction, Your Honor. I still haven't been shown any verified proof that
All rise.
this court has subject matter jurisdiction. And at this point, may I request an affidavit that you, Your Honor, have no bias, no conflict of interest, and no interest in the outcome of this case?
Mr. Brooks, the jury's coming out. We'll address your legal issues later. if I deem them appropriate.
Judge, do you hold the full
Mr.
judicial
Brooks,
power of the
please,
state, or is this the
please.
military
All right, can
power?
you please take the jury out? Thank you.
Do you hold the full
Mr. Brooks, just
jurisdiction?
wait till the jury's out, please. I ask that you show that respect.
I will. I will.
Thank you. Everyone else can be, you all can be seated. Mr. Brooks, just make your statements. What do you want to advise the court today?
I want to first state again for the record that I do not identify by that name, nor do I consent to being called that name. Your Honor, with all respect, I'm merely asking you, do you have the full judicial power of the state, or is this military power?
I'm sorry? I don't understand what you're asking me, sir.
I'm asking, is
And on what legal basis are you making that request?
I'm asking, for the record, is this a common law court or an admiralty court? What are we in here? And I'm requesting an affidavit that you, Your Honor, have no bias, no conflict of interest, or no interest in the outcome of this case. And the reason why I want to state this clearly for the record, mainly is because of the bias that's been shown. I have not been getting any certified copies of any requests that I've made, which I was told by this court to address inmate communication forms for anything that I may need. I've done that. I've complied with that. Every time I've needed something of the court pertaining to documents, I've done it the way the court has asked me. And I've always stated that I wanted everything to be certified. I have yet to even get that. My court docket sheet was not a certified copy. When I asked Your Honor of your oath of office, I asked for that to be certified. You stated for the record that you would not give me a certified copy of your oath of office, which you are required to show if I ask for it. I've brought up my Sixth Amendment constitutional right that has been pretty much discarded, and that is based on the fact that I have the right to face my accuser, which would be the plaintiff, state of Wisconsin, in this matter. They have yet to show that a claim is I mean, a living human being can only make a claim. An entity cannot make a claim. I've requested for the complaint to be provided. The complaint from November 23 of 2021. The amended complaint from November 29th of 2021. The second amended complaint from January 12 of this year, 2022. I have yet to see those. There was no record of a bond in my docket sheet. I asked for that to be verified by proof. That hasn't been provided. There's so many biases, clear biases in questions that are not being asked based on judicial determinations made by Your Honor. You look at the discrepancies, and I think they're clear. I think at minimum I deserve for the subject matter jurisdiction to be verified and proven. I've raised that issue numerous times, pretty much every day, every time I come before your court, Your Honor. I address that, and it has yet to be proven. My filings have been disregarded, even though they've been filed into the record, even though they've been time stamped. I haven't got the original copies of any of them, which I'm supposed to get. And as we sit here today, I'm still not even understanding the nature and cause of the charges. That hasn't even been proven. Can that be provided in any way? I'm basically sitting here confused because I don't understand why these proceedings are allowed to continue when there's so many things that have not been provided. They haven't been provided in my discovery. They haven't been provided to me by being brought to my pod where I'm housed in the jail. I'm without so much information, valid information to this matter. And I believe that it should be verified and it should be proven for the record. And if not, I move for this case to be dismissed for failure to appear by the plaintiff and failure to state a claim for which relief can be granted. Everything that I'm saying, it has merit and it has validity. As we sit here today, I'm still being charged with charges that shouldn't even exist based on the testimony that we've heard for the last few days. There's so many things left to still be proven. The prosecution team hasn't even proven that they're licensed to practice law in Wisconsin. They haven't proven, are they just bar association members, or do they have state issued licenses? That has not been proven, which I've raised that issue for the record. I'm not even sure if that was even recorded in the docket sheet. There's so many things, and Your Honor, you still haven't stated for the record if you have full judicial power of the state or is this military power. That hasn't been proven. Nothing has been proven. Not subject matter jurisdiction, not licenses to practice law. My Sixth Amendment right has been basically trampled over. No complaints have been shown. Neither of the three that I've requested, by the way that you told me to request them by inmate communication. Nothing gets certified that I get copies of when I clearly asked for them to be certified and to be filed into the record. It's to the point where Your Honor, you should recuse yourself from the presiding at this point. If you're not going to abide by the oath that you swore, which was in your oath, correct? You swore to protect the Constitution of the United States. You swore to protect we the people. That is not being done here. If every valid argument that I raised is taken by the court as a sign of disrespect or a sign of trying to intentionally be disruptive or causing a problem, when I'm merely seeking understanding, because I don't understand. I'm merely seeking to understand why this information has yet to be provided and we're this far into this matter. And there's still no verified proof. Even as I sit now saying this, there's still no proof being provided. Zero. How is this case allowed to continue without these documents and filings being verified? Is there any legal factual basis that can state why this information has not been provided? Why the docket sheet is incorrect? Why there's so much on the docket sheet that should be on record that's not even in there? That if we had the recordings of the record, they would see was brought up numerous times that doesn't even show up. I'm just asking for Your Honor to be fair, which is another right that I have, the right to a fair trial and the right to an impartial jury. I can go on and on and on about what's not being done. I have, again, I say I have the right to face my accuser. Where's the injured party? Who's making the claim? I asked Your Honor numerous times for Your Honor's name. You wouldn't answer. I asked, did you have a claim against me? You did not answer. I asked the whole courtroom, did anyone have a claim against me. No one said anything. Which you stated for the record, a non-responsive answer. A non-responsive answer is an agreement, which will be a tactic agreement by you, Your Honor, that you don't have to answer these questions that you should be answering. I have that right. The plaintiff in this matter, which was stated by witnesses in testimony to be the state of Wisconsin. But when I asked, do they see the state of Wisconsin present in the courtroom, the question is shut down, which is a valid question. The plaintiff should be present in this matter. Where is the plaintiff? Who's bringing the claim? Because we know an entity can't bring a claim. It has to be a living, breathing human being. No one is stated for the record if they're the injured party. Not Your Honor, not the prosecutors, not anyone in the court has stated to be an injured party in this matter. No one. Not one person. I have the right to demand that the court place in the evidence any unrevealed contract. Has that been provided to me? Have that been placed in the evidence? I would like to see it, which is my right. I have the right to inform the jury about the truth and their duty and their rights. That's the First Amendment and the Sixth Amendment. But I'm repeatedly told to shut the question down when this is valuable information that the jury should be privileged to know. They deserve to know. Once they were chosen to sit on this jury, why are we keeping information away from them that they deserve to know? They ultimately have the power. They decide the matter. Why are we keeping information, valuable information, from their knowledge? That's a disservice to the jury. And frankly, it's a disservice to the court that they're not allowed to hear things that they should know, that they should be informed of. It's our right to inform them of everything that they have the power to know, to do, and to know. They deserve that much. It would be a travesty for them to make a decision without being fully informed. And these are all valid things. I have the right to protest and object if any of my rights or demands are not being met. I've done that numerous times only to be shut down. Numerous times. I've raised the issues that I didn't consent to anything that may have been suggested on behalf of my former attorneys. I've never even consented to them making a plea on my behalf. I haven't, as a matter of fact, when it comes to a plea, I haven't even had the opportunity to entertain any plea that may have been suggested by the prosecution. We haven't even talked about that. Not one time was it ever brought to my attention that the prosecution even wanted to offer a plea. That's another issue. I have the right to challenge the jurisdiction of this court, which I've done numerous times. I have the right to demand that the code be construed in harmony with the common law. I just raised that. I'm constantly referred to as pro se when I've raised the issue that I'm pro per. I have the right to conduct my defense pro per, free from professional restrictions imposed upon licensed attorneys, which this court is well aware that I am not a licensed attorney. In fact, the court is also aware that I only had 3 days to prepare for a trial that the prosecution has been prepared for a whole year. We see these boxes right here. This box alone is 45 or 50 pounds full of so much information. I haven't even gone through half of it. It was stated for the record that the discovery, in its entirety, was brung to my housing unit on the 29th of September, which trial was scheduled, that would be a Thursday, which trial was scheduled for Monday. How can I possibly go through all that, all the paperwork, all the digital discovery and things of that nature? How can I go through all of that and be prepared in 3 days? That's a clear bias. I did not have time to prepare for this. Everything I'm doing is off the top of my head, winging it, taking it as it comes. When the court is well aware that I was not prepared, I raised the issue that it should be an adjournment, at least at the minimum, it should be an adjournment because of that fact, at least to let me go through all the discovery. That was denied. No valid reason was stated for that when Your Honor knew there is no possible way, humanly possible, that I could be ready for a trial of this magnitude in 3 days. That's clear bias. I have the right to face the injured party claiming damages. That's under Article 3 and the 6th Amendment. I raised that issue again. Where's the injured party? Is the injured party present in court right now? Can anyone make a claim against me? Can you make a claim against me, Your Honor? Do you know of anyone that can make a claim against me, Your Honor? Can anyone right now in court, anyone, make a claim against me? And because of that, Your Honor, the motion to dismiss should be granted based on that alone. There's no injured party in this matter. So who makes the claim? Who? I have the right to put the judge on notice of my intent to appeal and any ruling decisions during the case. You stated for the record that I would have to wait until appealing process, but my right is that I can raise that issue during the case, which I've attempted to do. That's been shut down. I have the right to specifically reserve all of my rights, which I do at the beginning. I have the right to say what I want and to be heard under the First Amendment. And when I attempt to do that, it's taken as a slight to the court, a disrespect to the court, or me intentionally coming into the court to be disrespectful, which I've stated that is not my intention. Never is it my intention. I never intend to walk into your courtroom, Your Honor, and be disrespectful intentionally. I never come into this courtroom to disrespect anyone. But because I don't understand, I raise these issues because they have validity. I have the right to object to any statement made by the judge or the prosecution. I've done that and been repeatedly shut down. Without a lawful explanation. I've repeatedly asked the court for a motion for a finding of fact to determine if things are being done legally. I've been denied that numerous times without merit, which is also my right. I have the right to recuse the judge at any time, which is also a right. I have the right to a speedy and fair trial by impartial jury. I think it's safe to say that my speedy trial right has definitely been violated because this matter has been taking place for roughly a year. I've never consented to waiving anything related to a speedy trial. And if that was done, it was done without my consent or without my knowledge. We're way past the speedy trial date. Way past. when the change of venue motion was brought up. I believe that was the first time I came before Your Honor in early March. I want to say March 11th of this year, when the change of venue motion came into play. It was decided by Your Honor that wouldn't be decided until the 20th of June, I believe. That's over the 90-day mark right there for a speedy trial. That was denied, and I still don't understand how that was denied when it's clearly obvious that at minimum the venue should have been changed based on the fact of the magnitude of the matter. There's no possible way anyone in this county would not have some type of connection or some type of knowledge, whether they were told something by someone that they may know. The news reporting alone, just that alone, there's no way that this trial should be taking place in Waukesha County. That's obvious. That's obvious from the way the motion was presented, the coverage alone, the political campaign ads that plastered the defendant's face all over the TV every single day. Every time a political campaign was brought up, it made reference to this incident. Every single time. The fact that people have children that go to the same schools in this county, that people may have worked with the same people in this county. You yourself, Your Honor, stated that you at one time worked with the father of one of the people that was injured in this matter. That is a clear conflict of interest right there. You also stated for the record that not only did you work with this father, but that at one time they may have donated to your, I don't know if it was to you becoming a judge, or I would have to look through the docket, but you said it on the record that they donated money to a cause of yours. You also stated that when you had gained knowledge of the incident and that their family member was injured in the incident, that you reached out via phone. I don't recall if it was text message or an actual phone conversation, but you put that on the record. You also stated that the nature of your relationship was strictly professional. I don't know about you, Your Honor, but I've worked numerous jobs, and I know what professional relationships is and personal relationships. I've never had the cell phone number of anyone that was a personal relationship saved to my phone that I could reach out immediately when I learned something. That would constitute a personal relationship of some kind. Whether hanging out from time to time, having a cup of coffee, or hanging out time for time, grabbing a beer, or hanging out from time to time, watching a game, or anything of that nature. It would definitely be more than just strictly professional. That was stated for the record. Again, I go back to the Sixth Amendment again. In terms of when I asked for the motion for the evidence motion that I raised, that was denied without any explanation. That would be strictly to place in the evidence any unrevealed contract. That's under the Sixth Amendment. Clearly, there's been repeated violations of my Sixth Amendment. We all know that the United States Constitution is the law of the land, period. It trumps everything. We also know that any law repugnant of the Constitution is null and void. We know that. There's still no basis for the motions being shot down. Why was I not granted the motion for finding a fact? Why did it take so long for me to be brought my entire motion for discovery? Why was the motion to prove jurisdiction not verified? Why was the motion to dismiss the case for all the reasons I said not being granted? Which brings me to the motion to subpoena witnesses. I did everything that was asked of me by the court pertaining to those subpoenas. It was understood by the court that this is my first time ever having to do this. I didn't understand how to properly fill out the subpoenas, at which the prosecution volunteered that they would give assistance. The only assistance I received was for them to check to see if it was filled out right. That was it. That doesn't amount to any assistance. I was still left to fill it out on my own, and then when I did that, correction still had to be made, which would verify what I was saying. I don't know how to do this. But I still complied to what the court asked of me. And even then, it was a big old thing about the subpoenas. I can't subpoena the plaintiff in the case. Well, how can I not subpoena the plaintiff in the case when under the Sixth Amendment, I have the right to face my accuser, which is the plaintiff of the case? So how could the subpoena not be filed, and how could the plaintiff not be called to the witness stand? That begs the question of, does the plaintiff even exist? Which it was stated for the record that not only by a witness, a Detective Casey, that got on the stand and said on the record that is an entity, which is not a living, breathing human being. And then it was stated again by you on the record, Your Honor, that the plaintiff is an entity. So the question still stands. How can an entity bring a claim if it's not a living human being? So where's the claim? Will the plaintiff in this matter, the state of Wisconsin, be allowed to testify? Will they be allowed to be in the courtroom? No, they will not, because they don't exist. Therefore, the claim doesn't exist. For all those reasons that I just stated, the case should have been dismissed a long time ago. Once those issues were raised, this case should have been dismissed. And at the very minimum, it should have been dismissed because those still have yet to be proven. We're still talking about jurisdiction. That's been being asked for over a week. There's still no providing of license to practice law yet. Not even by you, Your Honor. Why was I not provided with a certified copy of your oath of office? Why would you not state the name that is on file with the Secretary of the State? Or I made reference the first time to the Secretary of the Treasury, and then you stated on the record that it's the Secretary of State, even though you knew what I was referring to when I asked. You referred to your name tag, but that's not the name registered. We both know that. So why wasn't that proof verified? You gave me a copy of your oath of office, but it is not certified. So how can I verify that that is the true oath of office that you signed. How can I verify that it's valid? That's the reason why I asked for it to be certified, which you stated for the record you will not do that. You never stated any legal reason why. I have the right to ask for that legally. I also have the right to call any witnesses to assist my defense, which is the main reason why I subpoenaed the plaintiff in this matter. I also have the right to challenge all relevant laws in this trial in terms of their intent, interpretation, fairness, enforcement, and whether they serve and protect the people. From my knowledge, the design of the statutes of the law was written for the common people to understand. So that would mean the final determination or interpretation of what the law says comes down to the people. You know this, Your Honor. Are you not a public servant? You also know that this docket sheet is inaccurate. Every filing up until the point that I started representing myself was filed in a name that was represented by all capital letters, which is not my name. Nor has it ever been my name, nor have I ever seen that name or individual. Every single filing or paperwork was all in capital letters. Ever since September 29th, roughly around there, now everything starts to go to lowercase letters. Why is that? What prompted the sudden change? I still have filings that have all capital letters, which I state every time I come into your courtroom, Your Honor, that is not my name, nor do I consent or agree to being called that name. I'm merely here as a third-party intervener on behalf of my client. Did I accept for value in return for value? We go through this every time I come here. Every time. You bring up Illinois versus Allen when we had the issue of me being removed from the courtroom. We went through that where Illinois versus Allen states that there are 3 options when a defendant is being disruptive in court. You stated for the record that you identified a 4th one, which is not cited anywhere in that case. It's not cited anywhere. So the question would be, how did you come up with a 4th option that's not written in that case? Did you take it upon yourself to add this 4th option to justify denying me my constitutional right by being present? You could have done the 3 that were stated. Any one of the 3 you could have done that were stated in the case. Nowhere does it say you can create a 4th option. not upholding my constitutional rights. I'm sure you know about Title 18, USCS 2381, which states that it's treason not to uphold your oath of office. Treason. You repeatedly make judicial determinations that clearly prejudice my defense. And then when I question you about, are you making judicial determinations, I'm repeatedly shut down. Which leads to today. The constant push not to have an informed jury. Not giving legal valid grounds on objections. Not noting objections for the record to make sure that the record is clear. I'm sure somewhere in the jury instructions, you informed them that the state of Wisconsin was bringing a claim. But then you make the judicial determination that I'm not allowed to ask questions about the plaintiff. That's clear bias. And it prejudices my defense. You know also that you have an electronic filing system. I find it hard to believe that I was told yesterday about my subpoena for the plaintiff that I had to wait for a filing in a timestamp when I've seen it done numerous times in just a few seconds right in front of my face. When the prosecution needs something filed, it's filed immediately. I have to wait, or I have to wait till the next day. That's a clear bias and a clear prejudice to my defense. Obviously, the court knows that I'm not privileged to the same filing system. Which brings me to the reason why I brought up the issue of assistance of counsel. Under the Sixth Amendment, I have the right to assistance of counsel. It doesn't say anything about representing yourself without assistance of counsel. Having counsel represent you and having assistance of counsel is two totally different things. You, Your Honor, gave me paperwork that was a waiver of counsel. We both know that any contract can be altered if I don't agree to certain terms. I crossed out everything in that paperwork that I did not agree or consent to, and specifically wrote on that paperwork that I do not waive my right to assistance of counsel. At the very least, I should have been awarded a standby counsel. Not someone to represent me, to speak for me, but someone to help me do things in a timely fashion. Get things filed in a timely fashion. Get motions together in a timely fashion. Make preparations to get things done that I don't have the privilege to do in my current situation of being housed at the Waukesha County Jail. I gave you back that paperwork and you accepted the paperwork that I altered, that you understood that I didn't agree and consent to those things that were altered. You accepted it and you filed it. That is in the record. I have copies of the same paperwork that you accepted. So when you accepted that, with no objection, that becomes a tacit agreement. But yet, I'm still forced to come in here with zero help. I think it's clear that prejudiced my defense. Knowing that the prosecution has everything that they need for this matter at their fingertips. And I have to jump through every hoop possible to even get things filed in a timely fashion. It was stated for the record that the unit that I'm housed in the Waukesha County Jail, and per jail administrator Angela Wallenhoff, that I'm only allowed out of my cell for a few hours a day. So I'm roughly locked down 22 hours a day. Not given the privilege to access everything that I should be able to at the time that I should be if I was general population. Arrangements could have been made months ago for me to be at least in some form general population with an upcoming trial. Reference was made to being able to use LexisNexis or whatever it's called. We call it the law library. That may be the easier way to describe it. I'm only allowed to access the law library at certain times during the day. The rule of the jail is that when you're not in the day room, you can't access the law library, which is on tablets. We are not allowed to have those tablets in our cells. That prejudiced my defense. How can I work on my case? How can I look up certain case laws? How can I do any of this if I don't have full access to it? I even suggested some type of order that could be made by the court to allow me more time out of my cell, or to talk to jail administration about allowing me more time out of my cell to be able to use those when needed. And to be frank, in a proceeding of this magnitude, there should not be even a time where I don't have access to the materials that I need. If I'm not in the courtroom or sleeping, I should be awarded the time to work on this case, seeing as how I only had a couple days to prepare for a trial of this magnitude. Which brings me back again to the change of venue again. Even right now with trial going on, there's still political ads being shown every day that reference this incident. There's still talk throughout the jail about it. There's been a ton of hate mail received to the jail since the beginning of this. It did die down for a little bit, but it picked right back up the closer we got to the trial. Hate mail that comes from people right here in the city of Waukesha. Which gives more credibility to the venue needing to be changed. Yet and still that was denied. It's impossible for impartial jury to be found in this county. And that's not to discredit people in the county that can be impartial. It would be unfair to say that no one can be impartial. That would be accurate. But with the level of scrutiny that this whole incident has, the reporting, the Facebook groups, the constant, there were Facebook groups created because of this. The reporting live stream on Court TV has comment sections where a lot of insensitive and nasty things are said. The sheer insensitivity of some of the things that are said on there. I know a lot of people probably don't care about what I'm about to say, but it still needs to be said because it's truth. The fact of the matter is, that I have children too. Family too, loved ones too. That also have been ridiculed and had their names drugged to the mud and have threats towards them. Loved ones that had to leave their home because they were getting threats thrown through their mailbox. Children that didn't feel safe going to school because they were getting bullied behind what was being said. And that's not to sweep anything under the rug whatsoever. To constantly say and report this incident as attack, terrorism. It's unfair and it's insensitive. It's a definite tragedy. Definite. And that will never be swept under the rug. There's always going to be healing that has to take place. It's going to be difficult. And that should not be swept under the rug whatsoever. But it's very insensitive and unfair to not recognize that there's many other victims that never is talked about. And for people to paint a certain picture, mostly from this county, to put this picture out there, it's not only hurtful, but it's insensitive, and it's not true. I'm sure the court read through the motion for change of venue. I'm assuming, though it was a lot of paperwork in those motions, I think it was obvious that the venue should have been changed. Obvious. It's too many connections and it's too close. It's too close. If there was any chance for a fair trial and an impartial jury, it should not have been in this county. But yet it was denied without any validity. Zero. There's so much bias that's going on that and even with all this, for the record, we still have no proof of jurisdiction. We still have no bond on file in the docket sheet. We still have no plaintiff. We still have no claim. We're not sure of the relationship between you, Your Honor, and a father of one of the people that was injured. We're not clear on that relationship, no matter how well prepared the speech was, because it was a prepared speech. That was obvious. Where's the proof? I just asked that same question. Can an affidavit be given that there is no bias, no conflict of interest, and no interest in the outcome of this case? There's no proof if you hold the full judicial power of the state, or is it the military power?
Mr. Brooks, I've given you about 50 minutes to make your various arguments. You've now repeated yourself a number of times, so I'm going to turn to the state to see if they have any response. Go ahead.
Thank you, Judge. Judge, I'm going to summarize what I just heard by quoting from a case from the Eastern District of Wisconsin, federal case found at 2022 Westlaw 3045190.
Can you repeat that last
I'm
one?
so sorry. 3045190. Retzloff versus Moran. This case is talking about many of the topics that Mr. Brooks has now recited to the court, and simply states the majority of Retzloff's filing is incomprehensible jargon and cut and paste legal mumbo jumbo. Sovereign citizen theories are frivolous and wholly without merit. And the court goes on to cite to Bay, B-E-Y, versus the state of Indiana at 847 Fed 3rd 559 on pages 559 through 560, a 7th Circuit Court of Appeals decision from 2017. Mr. Brooks knowingly
to being called that name, nor do I know any individual by that name, Your Honor.
Please do the courtesy of not interrupting the state, as they did not interrupt you for over the almost 50 minutes that you spoke. Thank you. Please continue.
Your Honor, the record is very clear that Mr. Brooks knowingly, willingly, voluntarily, and intelligently insisted on representing himself in this trial. He has no constitutional right to stand by counsel, none whatsoever. The court patiently went through the form and advised him of many of the things he's complaining about here today. The resources of the state, the knowledge of the law, his ignorance of the law, and his words to this court, and I quote to the best of my ability, "It don't make me flinch one bit." That's what he told this court, whatever it was, 2 weeks ago. Now he's here complaining over and over and over again how unfair this is to him. It's highly offensive. I don't know, because unfortunately I was talking to my investigator if he accused this court of treason, but I certainly heard that word come out of his mouth, and it is absolutely shocking that he would throw such a word around so loosely in this courtroom. This court has been exceedingly patient, exceedingly respectful of his rights at every turn. At every turn. I want to address this claim that he only had 3 days to prepare for trial. It's absolutely a false statement. The record should reflect that he does have 3 banker's boxes on his table. The record should reflect that every time the state calls a witness to the stand, he swiftly and easily turns to those boxes, which appear to be alphabetized or organized in some fashion by the public defenders who turned it over to him, and quickly removes the folder of the witness who's testifying and effectively cross-examines that witness using notes from the public defender. We know that because he's tried to confront witnesses with the notes from the public defender. He is not going into this blind or with one arm tied behind his back. They did all the homework, and he's simply sitting here reading their notes, reading their cross-examination questions, and asking the questions, and then going on to his ridiculous questions having to do with his belief in the sovereign citizen movement. There's no way this record would reflect that this defendant is not adequately prepared for trial. He's never asked for a speedy trial. He makes conflicting statements. On one hand, you violated his rights because it's taken us so long to get to trial, and on the other hand, we're rushing him to this case and he hasn't had adequate time to prepare. He is not denied access to legal materials in the jail. The record is very clear from the jail administrator. It should not be confused. He misleads this court intentionally to say, I only get out of my cell 2 hours a day. That is a fact. That is for his own safety, so that other inmates do not inflict physical harm upon him. He has access to a tablet. He has access to a computer. Whether he chooses to ask for those resources is up to him. I would also cite the court to U.S. Ex Rel. George versus Lane, L-A-N-E, 7th Circuit Court of Appeals at 718 Fed 2nd 226, where a pro se defendant attempted to complain on appeal about his lack of access to a computerized legal research system, paralegal training, or law school education. The court rejected that contention and said, once a defendant has asserted his right to refuse counsel and conduct his own defense, he has no constitutional right to access those resources. And again, you warned him, Judge. You fairly warned him. And he basically acted as if you were insulting him and said it didn't make him flinch one bit. Much of the last 50 minutes, which this court has graciously extended him the opportunity to go on and on and on, is nothing more than legal mumble jumble. He's reading from some typewritten transcript. I can see that from where I'm sitting. I don't know who's giving him these materials, but he has an agenda here. It's to stall, delay, disrupt, intimidate, and it's not going to work. Thank you.
Objection to that. Your Honor, that's a load of crap.
Mr. Brooks, that's my opportunity now. I gave you about 50 minutes.
I just want to object to the disrespectful comments that was just made. I'm not trying to hold you up from what you're gonna say, but that's a load of crap.
Mr. Brooks,
For her to sit there,
Mr. Brooks,
for her to sit there,
objection is noted.
for her to sit there, Your Honor.
No, it's my turn. Let me go through this. I graciously gave you 50 minutes to raise all these various points that you want to bring up. I then gave the state an opportunity to respond. That is the proper procedure. I followed decorum. I followed civility. I did not interrupt you. The state did not interrupt you. Your objection to their characterization, it's noted for the record. I am going to render a decision at this point. Please listen, and please do not interrupt. As I indicated, the defendant spoke for about 50 minutes, raising a litany of complaints and issues and theories regarding his view of how this case has proceeded. Many of these issues, if not the vast majority or even all of them, have already been addressed by this court in one way or the other. Looking at, for example, his complaints about change of venue. It is true this court denied the change of venue motion. The court made a record at that hearing. I stand behind that record and that decision. The arguments made regarding that decision, which I would note he has yet to file an interlocutory appeal challenging that, are nothing more than speculative, without a basis in law or fact. To say that this jury is biased would be a complete miscarriage of justice and a mischaracterization of the process this court painstakingly took in order to obtain a fair and impartial jury. There is absolutely nothing on this record before the court throughout these proceedings to suggest that this is a biased jury. I stand behind my previous determination and the process that this court went through, including initially calling an unusually large panel for which the clerk of court's office sent the initial qualification questionnaire, and then ultimately a case-specific questionnaire was sent to approximately 1,400 jurors or potential jurors. There was ample opportunity for the parties throughout the proceedings leading up to the end of August to review those materials. There were numerous strikes for cause that this court entertained. Even prior to that specific hearing, the parties met, they conferred. The state agreed not to challenge the vast majority of the challenges to jurors brought by the defense. And then there was the hearing. Then this court, at jury selection, allowed for an indefinite number of strikes for cause. Many were granted, if not all. And then even on the day that the jurors were brought in, the court provided the jurors with a supplemental questionnaire dealing specifically with the issue of exposure to the political advertisements. And then each party had the opportunity to exercise 10 preemptory strikes, which is well above the number of strikes allowed for by statute, which would be 6 based upon the homicide charges, 1 extra for the alternates, which would be 7. But out of an abundance of caution and in the interest of justice, the court gave each side 10, for which many of those Mr. Brooks chose not to exercise, and then pursuant to state law, the clerk of court chose names to strike by lot. Again, there's nothing on this record before the court to suggest that this jury that we have is anything but fair and impartial. And I take issue with the characterization that they are anything but. They've been diligent, they take notes, they are attentive, they come to this court. As the case law says, there's a presumption that they come to the court without bias, and it's through the jury selection process that the parties and the court ferret out that bias. Many of the jurors who were brought in were struck for cause. Many others were not. But ultimately, we have a fair and impartial jury. As I listen to the litany of issues and arguments and complaints raised by Mr. Brooks, I would note that they are all unsubstantiated, conclusory allegations and assertions without an adequate basis raised in law and fact. There's been several misstatements by Mr. Brooks regarding either the record that's been made, items that's been provided to him, or the basis for the court either sustaining, I should say, or overruling objections, for an example. There's been a mischaracterization of his rights that he claims to have. As I have stated repeatedly, your constitutional rights are not absolute when you're in a criminal trial, meaning your First Amendment right is not unfettered. It is frankly no different why the case law is very clear. You can't yell fire in a crowded theater. No one has a First Amendment right to do that. In a criminal case, the parties have an obligation to follow not only the Constitution and the statutes that are applicable, but to follow criminal procedure, the rules of evidence. That is what circumscribes the rights that a defendant or the state has in a criminal trial. The issues you raise, for example, regarding subject matter jurisdiction are baseless, they're frivolous, and they're not anything this court needs to address further. The fact that you now are asking questions about whether this is admiralty court or a military court or a court of competent jurisdiction is frivolous. This court has jurisdiction over the criminal cases brought before it by the state of Wisconsin. In this particular case, these are allegations that criminal conduct occurred in the city of Waukesha. The city of Waukesha is within the county of Waukesha. This court sits as an elected official in the county of Waukesha to hear these types of cases. That is clear. The only argument or relief that I could discern through the course of those 50 minutes was Mr. Brooks's request that this case be dismissed for lack of subject matter jurisdiction. And as I have just indicated, this court has jurisdiction. It's not been raised. Let me rephrase that. The issue has not even been raised properly. There's never been a written motion. There's never been even an oral motion that would comport with 80201, which requires that the basis for the relief being requested be stated with specificity and be based in law and fact. The vast majority of the points that you raise, sir, are issues that you can raise on appeal. It is true, you have a right to an interlocutory appeal. I would not be the judge to decide any of those issues. So the fact that you complain about what I do, it's noted, the record is going to be very clear, all right? I have a court reporter who's taking down the record of everything that is said and done in this courtroom when we are on the record. And so I don't have to all the time say it's noted for the record because we're on the record. I sometimes do that to hopefully make it clear to you or to note it. I don't always do that, but I'm not required to do that. You raise issues concerning, I guess, plea bargaining. I have never been made aware that you would want to change your plea in this case, and that you're not aware of the state wanting to do that. That is the first time any such issue has been raised, and I see it as a distraction and as simply a statement made by you as part of the litany of things that you are not perhaps pleased with. As far as my conduct in this case, I already addressed those issues. I'm not going to revisit issues related to my familiarity with the father of one of the victims. That was done very early on. I made a very thorough record, and I gave the parties at that point an opportunity to address that after they had ample time to digest that information. While it's true you have a right to seek substitution of judge, it is not unfettered. There was a time limit for that. In fact, it was exercised because a prior judge was assigned to this case, and your attorneys on your behalf exercised that right of substitution. So to say that you have the right to seek recusal at any time would be a misstatement of the law. And even if you think that should be exercised, or there is a valid claim for that, sir, it's not been raised in the proper way before this court. This trial will keep going. I still expect the basic rules of civility and decorum to be followed. That includes, sir, that when there is an objection to a question that you ask, that you wait for the state to indicate their objection and the basis for it. If I need additional information, I will ask for it. If I don't need additional information, I will rule on it. And I do expect that even if you disagree with that ruling, that you will abide by it and that you will move forward. Whether that's asking a new question, rephrasing a question that you've asked, I do ask that you follow that simple rule of decorum, and that's you not interrupt, and then you follow the rules of procedure. As far as the other issues you raise concerning your right to assistance of counsel, the record before this court over the many days that that topic has been raised, even going back to the 2 afternoons of hearings this court held, I will not revisit those. I believe I honored your request to represent yourself as is required by the Constitution of not only the United States of America, but the Constitution of the state of Wisconsin. And that you made a very deliberate choice after being fully advised and aware of all the requirements that I needed to go through under the case law, both case law in the state of Wisconsin and case law from the 7th Circuit Court of Appeals, which not only guides this court, but this court must follow. I agree with the state and would draw your attention to the 2 cases that were cited. United States ex rel. George versus Lane, found at 718 F. 2nd 226, and Retzlaff versus Moran, found at 2022 Westlaw 3045190. I let you put on the record all of those points in order to give you that opportunity to make a full record of the issues that you have believed that you are entitled to raise. But those sovereign arguments regarding written findings of fact, bill of particulars, regarding contracts that you enter into, regarding admiralty court, etc., they're baseless, sir, and this court need not address them further. Now, with that, I know it's 11:30, but I would like to get one more witness on before at least we break for lunch. The jury, of course, has been out for quite some time, so I'll instruct Madam Clerk to bring the jury out.
For the record, Your Honor, you didn't bring up the Higgins-Levine 415 U.S. 533 decision. That was not addressed, and the issues are still not addressed. There's still been no proof to anything that you said, anything that the prosecution has said. It still hasn't been.
Objection is noted, and we will continue. Bring the jury out, please.
There still hasn't been
Mr. Brooks,
any proof.
I've addressed them
There
to the
still
extent
hasn't
that
been
I
any
will.
proof. There still hasn't been any proof. I never once. The comment about me not flinching was when you said that there's 66 years of experience at that table. That's the comment I said that doesn't make me flinch. That was mischaracterized. That should be for the record. There's still been no proof.
Mr. Brooks, please stop. I'm not going to address whether there's verified proof or not of jurisdiction,
Because
whether
it's not.
there's anything along those lines. It is frankly not required under the law. You may disagree with that. You can take that up on appeal, whether that's an interlocutory appeal or whether that's a direct appeal if there is a conviction. But I'm not going to address it any further.
Because there's no verified proof.
There does not need to be, sir. All right, I
It does
believe the
need to
jury
be.
is coming out. Is that true, Madam
In
Clerk?
order for a case to.
All right. The
to
record
go
should
on, there should
reflect
be
that
proof.
the jury is coming out, and we are about to continue with the state's next
Not once
witness.
was the plaintiff addressed. That wasn't addressed. Where's the plaintiff? Where's the injured party? That's because
The jury will disregard the statements presently being made by the defendant.
Because y'all don't want the jury to know the truth.
The jury will disregard those statements
I understand.
made by the defendant.
I see.
It is not his opportunity to testify.
I see what's
They are
going on.
comments, and as such are to be disregarded.
I see what's going on. Ain't gonna work.
All right. Thank you, everyone. You may be seated.
From the company that brought you Alec Murdali comes another special toy. Prison Playmates is proud to present our new prison pal, Dolly Brooks. Dolly Brooks comes with over 30 fun and quirky phrases.
Consent to or agree to being called their name.
Oh, Dolly, nobody cares.
Objection. Hearsay.
Dolly Brooks also comes with a unique set of accessories, like the big boy suit, the reversible mask, and his important documents.
Get your facts straight.
I'm not going to sit here and let somebody be inaccurate on the record and lie on the record.
Oh, Dolly, you're right. I forgot about the documents in this special box for just $15 extra. Are you happy that I mentioned them too, Dolly?
I just want the truth to be told.
But that's not all, Dolly, because for the first 500 orders, we'll also include these special shock shackles, absolutely free. What do you think about them, Dolly?
It should be noted that I had a shock device on my ankles. It is a fact. I was told that there were a shock device, which I know how a shock device looks because I've been through this before in Milwaukee.
Dolly Brooks is endless fun for all ages. You just never know what he's going to say next.
Can we move on to subject matter jurisdiction that hasn't been proved for the record?
Just remember, if you order now, you can get Dolly Brooks, his extra courtroom set, and the shock shackles for just $25.99. Don't wait. Call now.
I accept for value in return for value.
To order your Dolly Brooks, just call 867-530. That's 867-530. Call now.
You're gonna blame me. Lie to her. It's okay to lie to women. They're not people like us. I don't know. Hey, where's the other guy?
You could make a box fort. See, here's a box. You could pretend it's a fort. Actually, that sounds like fun. I want this. I'm king in here.
All right, Mr. Brooks, do you have any position on that? I am unmuting you. I would note he takes the headphones on and off throughout. He doesn't have them on. He's looking at a book.
I wish you would stop saying, look, I'm looking at the Bible. Thank you. It's not just a book, it's the book.
Can't disagree with you there, sir.
Yeah. How many people actually live by it, though? Anyway.
Sir, I'm contemplating putting an hour time limit on closing arguments.
I ain't doing no closing argument tomorrow.
The closing arguments will most likely be tomorrow.
I'm not doing it tomorrow.
Then you'll forfeit your right to give one, sir, because as
you can't force me not. What type of court is this where you can say you're going to force somebody not to be able to give a closing argument? How is that lawful law?
If you choose not to give one,
how is that lawful law?
This 32-year-old guy wants to spend a Sunday afternoon chilling with a 13-year-old girl after texting her about getting stoned.
You say, I want to make love to you. Have you ever seen people have sex?
Man, I ain't trying to hear all that because at the end of the day, I did what you asked me to do.
She asked for it. She didn't ask for it. You sent it to her. And even if she did, I mean, you're not supposed to be sending stuff like that to somebody who says they're 13.
But instead of taking responsibility, he tries to blame it all on the decoy.
Did you know she said she was 18 when I met her? Did you know that?
I've got the transcript right here.
No, I'm not going to sit here and let somebody be inaccurate on the record and lie on the record.
As he gets up to leave and makes the long walk to the door, officers are in position, ready to arrest him.
Sheriff's office. Hands up! Hands up!
He's then taken to jail. And later, he starts crying.
Oh, face that way. Face that way.
It's the shoulder.
Oh, nice and easy on you. There you go. All right. All yours. You okay?
No. It hurts bad.
Your shoulder?
Bad.
Well, it's gonna be sore, man.
Yeah.
But at least you know nothing's broken, right?
Nothing broken. Well, why do I keep having this throbbing, burning pain if there's nothing wrong?
I know the shoulder's struggling.
Bad.
Shoulder's worse than the knees, though?
Absolutely. I know something is wrong. I know something is wrong. My shoulder hurts too bad right now.
Sure.
I'm sorry, man. It hurts so bad I'm getting teary-eyed, dude. Like, seriously, I know something is wrong. And I haven't get any Tylenol. I haven't slept.
Sorry about that. Tylenol, that can just be their procedure.
Right. No, I was just asking. Because you've
already figured out you're not an idiot. You're not a dumb man. You're a smart guy.
Right.
I see that.
Help us understand something. Where were you going, Darrell? So these parents
I
know
want to understand
why their kid got hurt, just the way you want to know why your kid got hurt.
So a kid got hurt?
A lot of people did.
A lot of people got hurt?
Yeah.
Are you serious?
Yeah. Darrell, you were there.
No, I'm saying a lot of people got hurt.
Yeah, there's people hurt, man.
Like that?
To me, it's a pretty good injury if a doctor's got to check you out or you got a broken leg.
Yeah, so what do you call my shoulder? I'm just making a joke, but yeah.
Well, I'm not laughing because there's nothing funny about this.
No, I was just saying. No, it's not. It's never been that. Dude, I don't take my life as a joke. I was just making a joke about my shoulder when you just said, you know, if it's a serious injury, if you got to get looked out. And I was just saying I had to get looked out, but they didn't say it was serious. They treated it like, oh,
let's say spend the night.
You're the guy in cuffs, so it's hurtful.
Can I show you something? Hey, you? you?
Nah, I ain't got no, it look like whoever.
That's not you.
That's not me.
That's not you.
No, I don't.
Darrell.
That's a
Darrell. That's you.
That's you, Darrell.
Why you say it like that, man?
Because we talked about the honesty piece. You keep telling me that you tell the truth when you did do something. You take responsibility when you do something.
Now, I just want to say this. When you said it wasn't the end of the world type thing, it is. It's over for me. It's over. Can't see your family. Can't see nobody. It's no guarantee you're even gonna see tomorrow. I go to jail right now. I go to prison right now. At my age, there's no guarantee how long I'm gonna have to be in prison. There's no guarantee if I ever see my mama again, because she's getting up there. I used to think that I was a lot stronger than what I am, because my mom used to always tell me, you got my strength, you strong, you strongest. You know what I'm saying? There's nothing that you would go through that you can't get through because you have my strength. But it's like I struggle with a lot of times feeling like I'm a failure. It's probably a lot of times where I probably shouldn't even be here. I've made a lot of mistakes. A lot of mistakes. Almost 40 years old and I'm still going through case after case after case. It's almost enough to just be like, the hell with it, man. And you got beautiful girls out there that you want to see grow up. My sister never got a chance to see her kids grow up because she passed away. What the fuck do I have to live for? To sit in prison? Like, who would want to have their last moments in a place like this, or in a cell somewhere, or in a jail somewhere? If I had to sit in jail right now, my life is over. I know y'all probably just think, oh, he's just talking. And it's crazy, man. Can't believe, man. I can't believe this is how my story ends, dog.
So seeing as how you sat with the prosecution for the entirety of this matter, it would be fair to assume that you know who the plaintiff is in this matter.
Yes, I do.
And who would the plaintiff be in this matter?
The state of Wisconsin.
Is that an entity or a living human being?
It's an entity.
How can an entity file a claim? You are aware that only a living, breathing human being can actually file a claim. An entity cannot walk into anywhere and file a claim if it's not even a real person.
Move to strike the statements by Mr. Brooks. Also object to the question that was asked at the end as irrelevant.
Or the request is granted, the jury will disregard the statement and the question asked.
No, I definitely object to that, Your Honor.
Your objection is noted. Under 906.11, I shall exercise reasonable control over the mode and order of interrogating witnesses. Please move on to a new topic. Or the cross-examination, I will end.
Do you see the state of Wisconsin present in the courtroom today?
Objection, argumentative,
Grounds.
irrelevant.
Sustained. Final warning, sir. Next topic or the cross-examination, I will bring it to an end.
You don't got to keep doing that, Your Honor. You don't got to keep doing that.
It's my responsibility, sir, over this trial.
I'm informed. And
Thank you.
And
Next
I respect
topic.
that, but it's relevant for the jury to know the truth.
Move to strike, Your Honor.
Granted, the jury will disregard those last statements. They're
Objection
not
to that.
relevant. Mr. Brooks is not testifying. They misstate the law.
I object to that. That's not lawful law. It's
Noted.
not truthful.
All right, under 906.11, I am now stopping the cross-examination. Any redirect by the state?
Objection to that, and I would like
Noted.
a legal finding of fact.
Go ahead, Attorney Opper.
Your Honor, for the record, this is a video. I'm going to play about the first 5 or 10 seconds for the witness to identify it before moving on, please.
Objection, because this seems like a whole new exhibit. This was never mentioned before. It was never.
I haven't seen it. I can't rule on it, sir. So let me see it, and I'll take your objection under. I'll take the objection under advisement. Go ahead,
I
Attorney
have
Opper.
all the exhibits.
Go ahead, Attorney Opper. I haven't seen it yet. There's nothing on my screen that I see. It's now playing.
So now we just creating exhibits now. I have all the exhibits, and this was never in it.
Sir, do you recognize what's contained in State's Exhibit 178.
Objection.
Overruled.
Relevancy.
Overruled.
Leading.
Go ahead and answer.
Yes, I do.
What is it?
There was a still photo shown before of Mr. Brooks standing in front of the Ford Escape. This is the video in which that still photo was taken from.
Where'd you get this video from, sir?
From Mr. Brooks' social media account.
Okay. Your Honor, move to admit 178 and permission to publish.
Objection. Your Honor, I have all the exhibits. They were provided.
Mr. Brooks, I'll take that up along with the other two issues I still need to address.
But how can you play something that I didn't
Mr.
even
Brooks,
have?
I'll take that up outside the presence of the jury.
This
Your
is
objections are
mind-boggling.
noted.
This is
It's
mind-boggling.
overruled.
Mind-boggling.
Actually, Your Honor, I changed my mind. I would like to play the audio, please.
Sustained.
This is mind-boggling.
So we will play the entire video, Your Honor.
Is this setting the foundation?
It's relevant. You question
I
this
question him
detective
about
his knowledge.
the steel frame from the video. The video wasn't even in the exhibits that I received. And actually didn't even receive them. They
Mr.
were
Brooks, please
obtained.
stop. The video's playing.
D-Mark got that heat.
I just got a load worth about a half a ticket. 30 in the blicker when I'm out here chasing chicken. Was observant to the game when I used to play the benches. Now I swipe Da Vinci, got him looking at me different. I can't miss him, yeah. AR with extension, yeah. Venom when I kiss him, yeah. Kidnap you and misses, yeah. Work all in the kitchen, damn. Money by the ceiling fan. Shorty wanna take a chance, I'ma need a cash advance. Only fuck with real gritters, and I've been around gorillas ever since a little nigga fucking on my babysitter. Put some prices on a nigga, you know they gon' come and get you. You see how them hollows did him, now he look like Tyson hit him. I was in the slums, any weather I was still trapping, sliding on the pussy early morning, bitch you still lacking. Caught him in the mall, had to tuck it in my heel figure. You know I got steel with him, fully not that little pistol. Heard they putting cameras on the lights, bitch we still dealing. Give a fuck about the past, nigga I'ma still kill you. No love for the suckers, listen, put them in the field, we bliss them. Shoot out all the ammunition, they move like some caterpillars. Post this on your social feed, addies that extend release. 2 cent boy, your talk is cheap, I won't stop till you deceased. Coming out your face you bleed, carbons we gon' sweep the scene. Senses we gon' find the heat, take you out the movie screen. Got another low, how we playing with them digits. Weighing up them bowls, hella coke around the digi. Playing with them bloods, they gon' pop you like a skillet. Nigga, I'm a menace and that's word to Mr. Wilson.
I hate that song. Why am I singing? To be blunt, which I've been since the beginning of this trial, obviously, I see the whole strategy here by the prosecution. I see right through it. Don't have any cross-examination, mainly because you've already schooled the people getting on the stand on how to answer certain things.
Well, that is completely speculative on your part without
It's
any
obvious.
basis in law or fact.
It's obvious.
Sir, you said you wanted to raise a legal issue. What's the legal issue?
The legal issue is how is the state allowed to coach the
You're
people getting on the
assuming they
stand?
spoke to them and coached them.
It's obvious. I'm not stupid.
Well, I disagree with that, sir. Again, you could ask
All of a
questions to
sudden-
lay a foundation
all of a sudden the
with
state
these
don't got,
witnesses.
all of a sudden, for the first time in trial, all of a sudden now they don't got no cross. That's clearly a rush to try to get through the case. Hurry up. We just gonna let these people go.
Well, this
and
is
not-
argument.
Come on, man.
This is argument on your part,
I
sir.
see
It
through
is pure
I
commentary
just
at
want
this
that on
point.
the record. I see through it. I find that
All right,
very.
I'm having the jury brought
man.
out. I'm instructing you to
Come on,
avoid
man.
the commentary when the jury comes out, or you will
I didn't
forfeit
say-
your right to be
I didn't say
present.
nothing.
Before we do that, there's an issue that we do need to take up. So as long as the jury's out, we should probably discuss that. I would like to provide the defendant and the court with a copy.
So that had to
of
be said. So it's the defendant.
That's not how it was said.
That was how I
completely
said. You want to
disagree.
run the record back?
Mr. Brooks.
So I'm the only one. I got one. I
Mr.
got
Brooks.
one ear that work, and I heard that.
This
Come on,
is
man.
to
Come on,
benefit
man.
you so
No,
that
it's
you
not.
understand
Ain't none of
your
this to benefit
witness
me, so let's be
has
clear
a
about
prior
that.
record.
Your Honor, when I leave the table, I'm away from the courtroom and I have to elevate my voice.
So can
Your
you
Honor,
tell,
I
can you
believe he
explain-
has 7 prior convictions via OWI second from 2006.
Right, I need to take a break. This man right now is having a stare down with me. It's very disrespectful. He pounded his fist. Frankly, it makes me scared. And we're taking a break.
The fact of the matter is, just like I did with my opening statements, I don't have a well-prepared or rehearsed speech. I didn't look in the mirror and say certain points to myself over and over again to make sure I have them right or anything like that. I've chosen to speak from the heart. And now I'm going to speak from the heart. What you won't hear me do is argue facts. Trying to argue facts of this, facts of that. I'm not going to waste your time doing that. It's a little emotional. I apologize for the long pause. What you've been hearing from the prosecution, and not to take anything away from them, but let's call it what it is. You've been hearing a lot of rerun. Same things over and over and over. No different than when you turn on the radio and you first hear that song that you don't like when you first hear it, but they play it so much that eventually you start saying it, the words to yourself before you even realize it. And then you sit and you go, I hate that song. Why am I singing it? That's what's been happening. Rerun over and over and over and over and over and over and over. Attempting to make things stick in your head that simply aren't true. It's a lot of information that you guys should be privy to, I believe. And one thing that I believe that you have not been privy to is the truth of your rights and your duties. The fact that you and you alone have the power, not well-prepared DAs with well-prepared and clearly rehearsed speeches and exhibits and a lot of theatrics. Frankly, not the judge. You and you alone have the power. You and you alone decide what is truth and what isn't truth. You should be informed that you have the power to nullify any law that you don't agree with. Remember the power that you have. Don't for 1 second let it be taken away from you. I can never understand the position of sitting on a jury in something of this magnitude. So I'm sure there's a lot of pressure. I pray that the right decision is made. The right decision. Do what's right. Don't let the smoke and mirrors take away your power. Don't let the theatrics take away your power. Each and every one of you has a decision. Do what's right. Make the right decision. That's the magnitude of the power that you have. Just like this tissue is in my hand, this is everything. You have everything. Be at peace with what you decide. Have no regrets. Don't let this decision weigh on you after it's over. And again, I say the same thing that I said earlier. Same thing I said in opening statements. I'm not reading from any paper, any books. Everything you've heard in opening statements, everything you're hearing now is from right here. Everything. You have the decision. You and you alone. All of you. You have the decision. I know it's probably not proper, but you guys deserve a round of applause if you could get one. Thank you guys sincerely. And I know, and I have faith and I trust that you guys know what's right. Ladies and gentlemen, I don't think it's fair to just say guys, but I believe in your heart you know what's right. Thank you.
Madam Clerk, may I please get verification that the audio and video are working in the neighboring courtroom. All right, thank you. I do have verification. There are headphones on the table in front of Mr. Brooks should he choose to wear them. I see he's reading from a book at the moment. I do need to make a record that this morning, although Mr. Brooks was not raising his voice, there were repeated interruptions. I gave Mr. Brooks multiple opportunities to stop talking. I asked him repeatedly to stop interrupting me. I advised him that if he continued, he would forfeit his right to be present in this courtroom and would be taken to the neighboring courtroom. I believe I gave that warning at least twice. It's my hope that we can continue with Mr. Brooks in this courtroom. At some point today, I'll certainly invite him back over when I get through these advisements. I'm not asking for a response yet, Mr. Brooks. What I'm asking you for is whether you have any requests for jury instructions, or if in your review you think anything needs to be changed, deleted, added, etc. Do you have any requests as it relates to the jury instructions, sir? I would note he put 2 boxes right in front of where he's seated, so I can't presently see his face. He is unmuted. I've confirmed previously regarding the audio working, and I will just ask him a second time, sir, do you have any requests as it relates to the draft packet of jury instructions, whether that be any additions, corrections, edits, or deletions?
And Your Honor, would it be possible for the bailiffs to just move the boxes off the table so
Yes,
we can
I think
see?
that's fair. I'm going to advise the bailiff to remove the box so I can see Mr. Brooks. I don't know what he's doing behind there.
Hey, why do you tell them to move my box?
Because I couldn't see you, sir.
Or what?
I've asked you twice now, and I'll ask you a third time. Do you have any requests as it relates to the jury instructions? Any additions, deletions, edits, or otherwise?
Hey, man, you don't got to talk to me like that.
Do you have any requests
First of all,
related to the jury instructions, sir?
Yeah, I got requests. It ain't like they gonna be honored though.
As it relates to the jury instructions, sir, what are your?
I heard what the hell you said, man.
Well, Mr. Brooks, that was very disrespectful.
Yeah, and I've been getting disrespected since the beginning of this whole process. So welcome to the club.
Mr. Brooks, do you have any requests as it relates to the jury instructions? Sir, I understand you may be upset, and I really do, but I've made my determinations.
You don't understand nothing. You don't understand anything, Your Honor. You don't.
I'm going to mute him again because he's not answering the questions that I'm very clearly asking him, and I've given him 5 opportunities. Mr. Brooks, do you have any requests as it relates to the jury instructions? I'll unmute you for that answer.
I can't hear everything you're saying.
Mr. Brooks, do you have any requests as it relates to the jury instructions?
Yeah, I can hear what you're saying. I can hear what you're saying.
You just told me you didn't. So which one is it?
Yeah, I got the headphones on. You can't see that?
What are your requests as it relates? What are your requests as it relates to the jury instructions, sir?
Man, don't try to come with this whole little image, sir. Now it's all this sir and all this. Trying to put on this little act like you so worried about what's going on with me. You don't give a damn. Never did.
Mr. Brooks, you're being disrespectful again.
You've been being disrespectful. You've been being disrespectful.
Mr. Brooks, do you have any position on the verbiage of jury instructions 70 on page 65?
Don't ask me no question. Are you my accuser? Are you my accuser, Your Honor?
All right, he's choosing not to answer, so I'll mute him again. It's unfortunate that he's deciding not to participate in this. I agree with the state. I don't need to highlight that second paragraph. I will take that out, but I will include in the paragraph that reads, at times, Mr. Brooks has appeared from another courtroom, period. This must not influence your verdict in any manner. Mr. Brooks, do you have any position on that? Which is, so Jury instruction 70 has to do with the defendant proceeding pro se. I need the bailiffs to move the boxes away from his face. I need to be able to see him. He can keep them on the table, but they need to be moved off to the side. And if he does it one more time, then I will instruct the bailiffs to take the boxes away. Those are trial prep materials. If there's something in those materials related to jury instructions, he should take those out now. Mr. Brooks, one final time, do you have any requests as it relates to the jury instructions? Otherwise, I'm going to approve them. I'm going to take a break, and then we'll come back in the afternoon to go over verdict forms.
I didn't answer yes or no, so how do you consent to anything without me answering the question?
Are you going to answer the question, sir?
But you can't force me to do it. You can't just say, I'm going to do this. Because
sir, but you also can't stall the proceedings by failing to answer.
I didn't try to stall the proceedings. You the one that held me in contempt.
I never held you in contempt. All right, I'm going to mute him once again because he refuses to answer a very simple question about whether he has any requests as it relates to the jury instructions. I will work on making all the changes with Madam Clerk, finalizing the order. So we'll come back at 1 o'clock to finalize the verdicts. All right, sir, I'm going to let you make an offer of proof as to why you believe the photographs and the questioning about contact after the alleged incident is relevant.
It's relevant because these were sent by the witness.
It assumes a fact, not an evidence, but
You
what
want
is...
the letter too?
Hold on. Tell me the basis you believe there's been communication and why you believe it's relevant to her testimony.
It's relevant because it was testified to by what's the last guy, Guth, that he was told that the witness was supposed to be so deeply afraid of me and all this type of stuff. So if you're so deeply afraid and worried about somebody and this and that, why would you sneak and have contact?
Do you want to open up the door to the other act's evidence of...
That's not opening.
No.
That's not opening the door.
Sometimes in a court of law, when there are pretrial rulings, the testimony of a witness needs to be said in such a way not to run afoul of that. But if you keep questioning her about whether she's afraid or not, or why she wouldn't have contact or not, you are opening the door to that testimony. All of my rulings have been made to prevent what could be seen as prejudicial evidence. The standard's not prejudicial. The standard's whether it's unfairly prejudicial. But you can open the door to that, sir.
It's unfairly prejudicial that I have a document stating that November 20th never even happened, but yet and still the witness can get on the stand and lie on the stand.
Have you turned that document over to the state?
Come on, man. Y'all know that's not right. Y'all know that's not right.
Then you need to immediately turn it over to the state right now. It may become relevant, but no one has seen it. When did you receive the document? Hold on. I'm having you make an offer. When did you receive the document?
Okay, but I just want to state for the record, Your Honor, that is not fair. It's not fair.
When did you receive this document that you claim was sent by this witness?
It's not claim. It's for a fact.
Sir, it hasn't been established yet. I need to make a record.
So do y'all want the letter?
I want to see the letter.
What?
I want to see the letter.
Okay, so I got to...
And I want to know when you received it.
I got to bring that in. Come on, man.
Mr. Brooks.
Come on, man. Stop.
When you
Stop
aren't
it.
Even
You're a public servant, Your Honor. I respect your courtroom. I respect you. You're a public servant, though. Your job is to be the referee. Is it or is it not? You stated so yourself on record that your job is being the umpire.
So I'm going to make a record about what he's referring to in count 77. Okay.
What happened to that paper? Because it was on the table. Then when I come back in,
I need to make a record of a variety of things.
So who took my paper?
And you keep interrupting me. You attempt to divert everyone from what is being done this very second.
I didn't attempt to do anything.
Yes, you do it repeatedly, sir.
Whatever.
So you're doing it once again.
Whatever. Just make your record. What does the letter read?
You have the letter. You showed it to me, sir.
And I've been trying to find it ever since I came back in here. And now all of a sudden I can't.
And now you're impugning, though, like somehow you're impugning the integrity of this court, of the bailiffs of this state. You're accusing, frankly, everyone of moving your papers.
Did I point the finger at anyone? Did I say anyone did anything?
Not directly, but indirectly you did.
So
sir.
how can you make the assumption that I'm saying?
Can I please make the record without you interrupting?
Yes, you may. Yes, you may. I apologize.
I appreciate that. Thank you. But you made repeated comments, sir, and if I need to, I'll have a bailiff put on the record that no one touched your table.
Your Honor, did I say anyone touched my table? I didn't
You
say
implied it, sir.
But did I say that? I can see if I came in and said, hey, one of you moved something off my table, then it would be more of a validity to what you're saying.
I need to continue with the record, sir. It's very apparent to me, sir, that every time throughout this trial, and especially the last 2 days, when the court makes a ruling that you disagree with, that you start peppering me with questions. You question me about the law. You ask, is it verified law? It is, from my perspective, a clear attempt to kind of turn us in a direction away from what we're doing.
I'm sorry.
That's my perspective. That I'm making a rule. You're doing it again.
I mean, because it has no validity.
So, I am trying to make a record about a line of questioning you want to ask Ms. Patterson. Now we have you claiming that there's some document that was sent by the witness after the charges were filed that apparently contained photographs that you believe goes to the credibility of this witness. So I need to ask a few questions about that, sir, to determine whether it has relevance to those issues. Number one, when did you receive this letter?
I received this multiple letters, actually, over a period of time. It wasn't, I referred to this one because this one had the pictures.
Does it have a date on it? The letter?
No, I didn't bring the letter. I brought the pictures. The witness knows that they sent me the pictures. They know that.
Well, again, it assumes facts that aren't here. You're assuming this witness sent it. I don't know. But even if she did, what relevance does it have to her credibility before this jury?
It goes to the credibility because she's put on this facade of being so afraid of someone, but yet still, you know that we're not supposed to have contact, but you still sneaking behind and saying, oh, I wonder how you're doing, and oh, this and this and that. Oh,
I don't think she's ever said she was afraid. I think that was the officers who may have stated that. So again, I'm going to ask you, even if this letter's from her, these pictures are from her, how does it relate to her credibility before the jury?
Who else could these pictures be from?
I'm going to ask you point blank. Did you get a letter that's signed from her?
I got. What do you mean signed? No
How do you know?
Letters.
What's your why do you have a belief that they are from her?
I have multiple letters from her.
You're not answering my question. Why do you believe the letters are from Erica Patterson?
Because they were sent from Erica Patterson. Why else would I?
Were they signed by her?
What do you mean signed?
Did she write her name on the letter? Was it the content of the letter? No, I'm not kidding you. I need to make a record, sir. You're making a statement that these letters are from her and that they're relevant to her credibility.
Your Honor, I'm going to go out on a limb here.
And I'm asking you why you hold that opinion.
I'm going to go out on a limb here and assume, which I know is true, you've never been in my position. You've never been in jail. So you've never received a letter from someone writing someone in jail. No one is going to... When you
You're
say
not
to
answering my
me, when
question,
you say to
sir.
me,
What's the basis why you believe they're from Miss Patterson? Is there some information in them that only she would know? Did she sign the letters? Is it penmanship that you recognize? Why do you believe they're from her as opposed to somebody else sending you information? Could be your mom, could be, I'm just saying, could be anybody else. You got to answer my question. It's called an offer of proof.
But you still got to understand why this is mind-boggling to me. Like, how I got a child with this woman. Why would I not know her handwriting?
But you have to lay a foundation for these letters, sir. That might be through your own testimony. So that I'm trying to figure out why you believe they're from her. Not all this other stuff
Are
about
you
I'm in jail
serious?
and I have a child. I'm trying to I need to know. It's called an offer of proof.
Are you serious?
What do you believe? Why do you believe they're from her? I am serious. I need you to
Because
answer.
they're from her.
But you're assuming
Like how else am I supposed to answer that?
I've given you a few reasons why it would lend to that opinion.
So it has to be put in a legal
The
term.
bottom
or
line is
something?
I need the letter. So if you're going to question her on that, the state absolutely has a right to see the letter.
So
The
what
state
about-
has the ability to question you about that or question this witness and to look at the veracity of what your claims are here. So I may take an early lunch. If that's in your cell, then you can go get it and bring it. But without that letter, I'm not allowing this line of questioning. Do you have the letter with
So-
you in court?
I just said no. How many
Okay.
times I got to say the same thing on record?
You know, sometimes, sir, I don't hear what you say because you interrupt me so much or you answer quietly. And I'm taking notes and I'm focused on probably a dozen things at the same time.
But if I say something under my breath, everybody seems to hear it. Everybody seems to hear
In
that
a
just
quiet
fine.
courtroom,
And everybody
yes, we can
assumes,
hear it very
and
clearly.
everybody assumes that it has to be disparaging. Or,
Once again, you're doing this tactic.
Because
you try to
it's
go
not a tactic,
off
it's
of what
facts.
we're talking
It's
about
facts.
to some other reason.
It's facts.
to
Because
some
I
other
find it
thing.
hard to believe that
I'm going to
all
let
of
the
a sudden
state.
nobody hears what I say.
I'm going to let the
Come on,
state
man,
make a
stop.
record of why they
Stop.
believe it's objectionable because I haven't let them do that. I've given you multiple opportunities to tell me why you
So
believe it's.
I didn't get these pictures from nobody else. Why was
The
somebody
record will
else
reflect you have 2 pictures that you believe were from this witness.
that I know is from?
No, that you believe.
That I know.
All right, I'll ask the state their position on all of this.
My position, Your Honor, is that these pictures, first of all, should not be admissible. 1, because of a discovery violation. We've never seen them before. 2, because we have reason to believe that he did not get them from Erica Patterson. He is on a jail phone call talking to his mother, Dawn Woods, about Dawn Woods sending these photographs to him. Now,
that's a lie. I object to
Let
that.
the state make their argument without interruption, sir.
That's a lie, though.
3, I believe that these photographs are designed to make a suggestion to the jury that Erica Patterson is a bad mom. I think that is what the defendant is trying to do. And if we're going to go down that road, then we would be forced to counter that claim. First of all, it doesn't make her an incredible witness, if it's even true. And second of all, if we go down that road, we would be forced to counter that claim by pointing out that not only does the defendant not live with the child in question, he doesn't live with any of the other children that he has. He impregnated Erica Patterson when she was a minor in Nevada, and for doing so, he was convicted of statutory sexual seduction, pled guilty in March of 2007 to that felony offense, and is a sex offender on the registry as a result. So if there's any causation that would lead to Erica Patterson being a bad mom, Mr. Brooks has a direct role in that causation.
And that's
Furthermore,
I object to that.
I'm not
because
done.
that's a lie.
Let him
Because at the end
finish.
of the day,
Let
if
him
we
finish,
gonna open the door
Mr.
on that, no,
Brooks.
since he want to make a record and not be accurate, so let's be accurate all on the record. Since you think you know so much,
Once
so
again,
we can
Mr.
open the
Brooks
door
is
on.
being
We can
loud,
open the door on how old she told me she
disrespectful,
was when we met.
interrupting.
We can ask that question
He is
too. Then
over the
Did you
top,
ask that?
animated
Did you
right
know
now.
that?
Mr. Brooks, I'm ordering you to sit down and to let the state
No,
finish.
I'm not going to sit here and let somebody be inaccurate on the record and lie on the record.
Right. Under Illinois versus Allen, I've warned him repeatedly. He's being removed from the courtroom. And you know what? Let me dial that back. We're just going to take an early lunch, 1 hour. We'll be back. And unless he brings that letter and he can show it is inadmissible, she will not be questioned. And under 906.11, I will declare the cross-examination closed. Thank you. We're in recess. 1 hour.
Get your facts straight. So let's open the door on all of it then, so we can get all of it on the record. Since you think you know so much. Did you know she said she was 18 when I met her? Did you know that?
I don't think there's anything else I need to cover at this time, unless there's something from either one of the parties. From the state first?
No, but we would like some further direction from the defendant as to who he wants here tomorrow morning and tomorrow afternoon, if he wants us just to continue that list that he originally provided, or if there's an update. And we can do that off the record, Your Honor. I don't know that we need you involved.
Okay. Thank you. Then hopefully the parties can figure that out without me needing to be involved further. But anything from you, sir?
No, I'm just gonna say with that, I'm not gonna put them in specific order.
Not looking for the order, but we're behind given the timetable and the understanding between, as I understand it, between you and the state. So,
The state has the list.
well, based on the groupings that you gave to the state, it sounds like we got through only one from each
Right.
kind
One-
of category. So we'll go back to the first would have been Thursday morning. You need to call the rest of Thursday morning. Was there 2 left of that?
Yes, correct.
So
And so let's do Thursday morning and Thursday afternoon. The people you designated, I'm going to direct the state to have here tomorrow morning. That's 4 witnesses, whatever order of those 4. And then how many does that leave? Because
that's what I'm trying to
doing
figure out.
good with math this
4.
late in the day. 4, so 4 in the afternoon then. So our hope is to get through all your witnesses
I can say this
tomorrow.
for the record. One witness I intend to call tomorrow is not going to be 35 minutes.
Fair enough. Do you plan to call that person in the morning or the afternoon?
I'm leaning towards the afternoon. If the morning goes pretty.
Can you tell me which list they were on when you gave it to the state? Was it Thursday afternoon, Friday morning, or Friday afternoon?
I didn't put them on days, but I believe they were in maybe the second floor names. If
Do you just want to tell me who it is so we can prepare so that person is told to come in the afternoon rather than wait through the morning?
I don't want to say who it is.
Well, I want the person to be here when we're ready to go, but
They were here today, if that helps.
Yeah, I know who it is. It's Erica Patterson, Your Honor. There's no
Maybe.
mystery here.
Maybe
all right,
it is,
that's
maybe
what I
it isn't.
would have. That's kind of who I thought it would be as well.
So,
I'm going to have her come tomorrow afternoon. Then. I'm
okay,
not
we
gonna
will
have
have
her
you
come in the
here at
morning.
1 o'clock tomorrow afternoon.
So we
Thank
need to be
you.
mindful of people's schedules.
Thank you. We'll have everyone else here at
That's
8:30.
interesting because what if that was not who I was referring to?
Then you need to tell me right now so I can make an alteration to that.
Come on, Judge.
Sir, we're at the end of the 3rd week of trial.
So
I
can we
need
at
to
least
keep
be
this
fair?
moving
Can we
along.
at least be fair and say that's not due to me though?
That would not be fair to say.
How?
It's
how? The state said that they needed 5 to 7 business days to present their case. Did they or did they not say that on the record?
And there's
So
it
how
doesn't
did
matter how we got there at this point. I'm trying
Then they
my
need to chop,
darndest
chop.
to get all the
Should've been
witnesses
chop, chop.
done. So I'm directing the state to have Miss Patterson come tomorrow afternoon.
If that's
And the
what I was
other
referring to,
witnesses?
which I wasn't, but everybody think they know what I'm thinking.
Then you need to tell them if it's someone else, and if you want her here in the morning.
I'll
then
say
that-
this. Everybody that was here today that didn't get called, have them here tomorrow. So that'd be 1, 2, 3, 4, 5 people.
And you need to tell me who you want in the morning, not by the order, and who you want for the afternoon. Otherwise, I'm going to make the order that I just made.
No, how you gonna make the order for me?
Under 906.11, sir.
No, you can't. I can call. I have the right to call them in the order that the state didn't have to have an order. And I'm guessing.
No, but the
correct me
state's
if I'm wrong, but
helping you out in terms of the order,
They were helping me out with serving
and
the
they're helping you.
subpoenas. Not the order of how I would call the witnesses, but the subpoenas. And I gave the state.
Do you want to be responsible for calling each person tonight and telling them what time they need to be here, or should we let the
See,
state
here we
do
go
that?
with this again. There's something that's impossible to do.
That's not true. You have
How's it
access
not
to
true?
a phone.
So somebody's gonna answer a collect call from someone they don't even know. Nobody in this courtroom will answer a collect call and pay for a phone call from
not
somebody
my
that you
understanding
not know.
of how it works at the jail. That you can.
Yes.
There's other means to make phone calls.
There is no other way to utilize the phone.
Well, maybe I'm wrong on that, but be that as it may, the state is helping you out. This is to make tomorrow go as smoothly as possible, to be effective, and to use all of our time wisely.
Your Honor, with all respect, I did what was asked of me to do. I provided them with the list of the witnesses that I will call. And I stated before that I would not put them in order, and the state accepted the list that I gave them. So why, at this point, is
Who are the witnesses who are here
being
today?
a problem?
Kohler, Douglas Kohler, Detective Guth, Erica Patterson, Christopher Bertram, and Jason Hayes were here today, in addition to Miss Reimer. Miss Reimer's now done. Nicholas Kirby was also here today. He's done. If we are going to continue to assist Mr. Brooks in getting these witnesses here, we need to have a reasonable time schedule. These witnesses don't just show up by the tooth fairy. We have to communicate with them. They have jobs, they have families. I've explained this 3 times to Mr. Brooks. If he wants our assistance,
objection. She can chill with all that. She can chill with all that tone.
Hold on. I know.
Get on that if that's what it is.
Hey, I know it's been a long day. Let's keep this civil.
That's what I'm trying to do, but she gonna have to tone it down.
I think both of the parties are getting a little frustrated. I'm getting frustrated. So, Kohler, Guth, Hayes, Patterson. I missed a 5th.
Bertram.
Guth is a police officer, right?
Yes.
I know who Eric Patterson is. How about Kohler, Hayes, and Bertram? Are those citizens?
They're citizens that relate to the parade, I believe, and post-parade, not the DV.
It seems to me that even with one of the witnesses taking more than 35 minutes, that doesn't fill up the whole day. So we need to have some other people on that list for the afternoon.
So I will just continue to work in the order of the list that was provided, Your Honor. I think that's the only reasonable thing we can do at this point, or we can do it alphabetical, or we can do it by random lot, because I don't know really what else to do.
By the list that was given.
What was the order of the list that you were given?
The first 3 were Kirby, Kohler, and Guth. The next line has 3 names: Patterson, Bertram, Hayes. The third line has 3 names: Reimer, Aldrich, and Lescano. The last list has 2 names and then also reads the state of Wisconsin.
First 3 people on the list you need to advise to be here tomorrow at 8:30.
Okay.
The next 2 people tomorrow at 10:30. The next 2 people after that tomorrow at 1:30. And the next 2 people from there at 3:30. And then do I have anyone left over from there?
No.
If I have to go late tomorrow, then I would say the last person can be at 4:30 if need be.
Yeah, I agree. We would very much like to get through the defense witnesses tomorrow, Your Honor.
I don't know if that's going to happen.
Well, that's the order that I'm making in terms of the times people need to show up. That gives you a range of people to select from.
I'm going to have to see that, what you're referring to then, because...
Oh, I trust you wrote it down, because that's what I did.
I
so
didn't.
We are at recess then for the evening. We'll see everyone tomorrow at 8:30 a.m.
So if they don't get called like that, don't try to blame it on me. To be blunt, which I've been since the beginning of this trial, obviously, I see the whole strategy here by the prosecution. I see right through it. Don't have any cross-examination, mainly because you've already schooled the people getting on the stand on how to answer certain things.
Well, that is completely speculative on your part without any basis in law or fact.
It's obvious.
Sir, you said you wanted to raise a legal issue. What's the legal issue?
The legal issue is how is the state allowed to coach the people? You're
assuming they spoke to them and coached them.
It's obvious. I'm not stupid.
Well, I disagree with that, sir. Again, you could ask questions to lay a foundation
all of a sudden the state
with these witnesses.
All of a sudden, for the first time in trial, all of a sudden now they don't got no cross. That's clearly a rush to try to get through the case. Hurry up. We just gonna let these people go.
Well, this is argument.
Come on, man.
This is argument on your part, sir. It is pure commentary
I just want that on the record. I see through it. I find that very...
I'm having the jury brought out. I'm instructing you to avoid the commentary when the jury comes out, or you will forfeit your right to be present.
Before we do that, there's an issue that we do need to take up. So as long as the jury's out, we should probably discuss that. I would like to provide the defendant and the court with a copy.
So that had to be said. So it's the defendant.
That's not how it was said.
That was how it said. You want to run the record back?
Mr. Brooks.
So I'm the only one. I got one ear that work, and I heard that.
This is to benefit you so that you understand
Ain't none of
your
this to benefit me,
witness
so let's
has
be clear
a prior
about that.
record.
Your Honor, when I leave the table, I'm away from the courtroom and I have to elevate my voice.
So can
Your
you
Honor,
tell-
I
can you
believe he
explain-
has 7 prior convictions via OWI second from 2006.
All right, I need to take a break. This man right now is having a stare down with me. It's very disrespectful. He pounded his fist. Frankly, it makes me scared. And we're taking a break. Mr. Brooks, the live stream is on.
I don't care about no live stream. Just like y'all don't care. All this political, this the show. Y'all getting told what to do.
Mr.
Y'all
Brooks.
getting paid what to do.
Mr. Brooks, look at me for a minute. Mr. Brooks. Mr. Brooks,
Sit
look
up
at
here, act like you know me. People like you don't. Y'all
Mr.
you don't
Brooks.
know nothing about where I come from.
Mr. Brooks.
Push me, dog. Don't push back then.
Mr. Brooks.
Don't push back. Push me again.
Mr. Brooks, we have to continue with this hearing.
Want to talk to the judge or not? I'm worried about, man, don't put your hand on me, dude.
Nobody put their hands on you.
Yeah, they better not put their hand on me.
Okay, Mr. Brooks, you need to look at me for a minute, okay?
Why? To listen to all this political stuff y'all got going on?
Mr. Brooks, I'm more concerned about...
Don't touch me, dog. They see it. They see it.
All right, we're going to take a break and we're going to come back after lunch. I'm not going to do this with him right now. He needs to be here. He's not cooperating. I'm going to give you the warning, Mr. I will give you the warning that if you continue to interrupt when we go back on the record, you will forfeit your right to be in the courtroom today. I can't have these interruptions. I want you here. It's been a long day and a half.
Keep your hands off me.
We'll come back at 12:30.
I just told you, get off me.
12:30, everyone. Answer.
Yes. All right, thank you, Detective. I don't have any other questions.
Any cross-exam for this witness, sir?
Yep.
All right, thank you. Begin when you're ready.
So, Officer Rowe, you repeatedly referred to the alleged defendant's name. How did you come into that information?
Based on the entirety of the investigation.
And when did you come into the knowledge of the alleged defendant's name?
I don't remember.
When did your part of the investigation start?
After he drove the SUV through the parade, I was called at home to come in and help the departments with the investigation.
And just so we clear for the record, is the jury asking you questions or me?
I'm sorry, I did not hear the question. Repeat your question, please.
Well, I was referring to when I ask a question, he turns towards the jury as if they're the ones asking the question.
That's not a question, Your Honor. That's
It is a question.
We did ask a question about that.
Yes.
I think you're asking why does he do that? To that extent, the witness may answer.
I'm here to present the case to the jury.
So, I follow that fundamentally. But for the sake of making sure you hear the questions right, wouldn't it be fair to say that you should pay attention to the questions being answered, or being asked, rather?
Assumes the fact, not in evidence.
Sustained as to the form of the question. Please rephrase.
Wouldn't it make sense to focus on the questions so you can hear them clearly?
Objection argumentative, still assumes the fact, not in evidence.
Sustained.
You made reference to you being here to present the case to the jury. So is that the reason why you decided to testify?
Objection to the relevance?
Grounds?
Overruled. The witness may answer.
I don't understand your question.
Were you able to hear my question clearly?
I don't understand your question.
Were you able to hear my question clearly?
Objection argumentative, Your Honor.
Sustained. Next question, please. Or rephrase the previous question to the one that was asked just now.
What was not understood about the question that you were asked?
Objection argumentative.
Grounds?
Sustained. As to the form of the question, please rephrase.
What wasn't clear about what I was asking?
Same objection, Your
Grounds?
It's the objection is sustained. Let's go back and ask the question that he says he didn't understand and rephrase it, please, or move on. Your choice.
Was your sole reason for testifying here today?
Objection relevance.
Let's let Mr. Brooks get the question out. Go ahead.
Apologize, I thought that was it.
Are you testifying today strictly to prove your case to the jury?
Objection, misstatement of his testimony.
Grounds that that's what he said.
Sustained as to the form of the question, misstates the prior testimony.
That's what he said. So why did you decide to testify here today?
Objection, that's a legally inaccurate question, Your Honor.
Please rephrase the question. I'm sustaining the question asked as to the form of the question.
I don't know how I'm supposed to rephrase that. Without having the same form of the question. That helps.
I'll rule if there's an objection, but ask a question, please.
Did you seek to testify here today in this matter?
No.
So how did you ultimately come to that decision?
Objection, that's a misstatement, Your Honor. It was not his decision.
Sustained as to the form of the question assumes a fact, not an evidence.
Were you subpoenaed?
Yes.
Do you recall by whom you were subpoenaed to testify?
District Attorney Sue Opper from the Washington County District Attorney's Office.
And at that time you were subpoenaed, you decided to testify?
I don't believe it's my decision.
Well, it would be fair to say that you didn't have to show up, right? That'd be fair to say?
No, I had to show up.
But would it be fair to say that you could have chosen not to?
No, it would not be fair to say that.
Exhibit 131 that was shown to you. Have you seen that video footage before today?
Yes, I have.
Do you recall who showed it to you before today?
I don't recall who showed it to me.
Would it be fair to say you've seen it multiple times before today?
Yes, I've seen it a number of times.
And do you recall when you were first shown that video?
Not off the top of my head.
Was it the same day of the incident, the days following, sometime after?
I don't recall when I saw the video the first time.
And what about Exhibit 130? Had you seen that video footage before today?
Objection, Your Honor. 130 is the map.
Or the map? Had you seen the map before today? I don't really think it's...
Just for the record, I'll sustain the objection just because it referenced the wrong number, but I believe you rephrased. So go ahead, the witness may answer.
Can you ask the question again, please?
Had you seen the map of Exhibit 130 before today?
Yes, I have.
Multiple times as well?
Yes, numerous times.
Any idea why you viewed it so many times, multiple times?
Unsure.
Were you able to obtain any more information upon seeing the map numerous times that you didn't obtain when first seeing the map?
No.
So it would be fair to say you pretty much knew what the map was detailing each and every time you saw it?
Yes.
And on that map, Exhibit 130, you made reference to at some point the dotted line, and it stops at some point. That'd be fair to say?
Could you be more specific?
The dotted line that was referred to on the map.
Do you want the map brought up? Would that be helpful to you?
Or maybe might be helpful to him.
He's got the large map, but if you want to...
So, if you can see the dotted line on the map behind you.
Yes.
Is it fair to say that the dotted line stops at some point? Around Central Avenue, maybe?
Yes, there's a couple lines that seem to come to Central Avenue or egress out of Central Avenue that do stop.
And you stated that, well, what was the reason that you stated that that line stops, the dotted line?
I stated that it's because we don't know the exact location where you crossed the street to get over to Elizabeth Street.
And why, were there no cameras present at that point, or how did you lose the path of travel at that point?
We didn't find any cameras or any eyewitnesses in that area.
So it would be fair to say at that point you weren't sure what happened.
I know that you crossed the street at some point. We just don't know where.
How do you know that?
Because you were arrested on Elizabeth Street.
Did you see any crossing of, I think you said that was West? Would that be West Avenue that you were referring to, that you don't see any crossing of?
What's your question?
Is that West Avenue that you stated that you didn't see any crossing of?
That is Northwest Avenue.
Or Northwest Avenue, I'm sorry, I don't know the streets. Northwest Avenue. And you don't have any visual footage or any eyewitnesses, as you said, to say for sure if Northwest Avenue was crossed?
We didn't obtain any witness statements or any eyewitness or any video of the suspect crossing the street.
And what day were you doing your part of the investigation? Was that the same evening or the next few days after the incident, or?
Can you clarify which investigation you're talking about?
The one that you took part in. Your part of the investigation.
I don't understand what time frame you're asking for.
What day did you start your part of the investigation?
Well, we started the investigation as soon as he ran people over in the parade.
And you were there?
I responded to the parade after he had done that.
Were you at the parade?
No, I was not.
So it'd be fair to say you were on call?
No, I was not.
So it'd be fair to say you don't know when your part of the investigation started then, right?
It would not be fair to say that.
You don't recall what time it was when you started your part of the investigation?
As soon as I responded.
And you don't recall when you were dispatched to respond?
It's in my report. I don't remember the time exactly, but it's in my report.
And at that time, did you know the identity or name of any alleged suspects at that time that you were dispatched?
The time that I was sent to the city of Waukesha, I did not know the identity of the suspect.
You made reference to a report. Do you recall when you wrote that report, or did you write the report yourself?
Yes, I typically type my own reports.
And do you recall when you submitted that report?
I have no idea what day I submitted the report.
So when you were first dispatched, what did you do?
I drove to the city of Waukesha and met with members at the Waukesha Police Command Unit.
And were you dispatched to any location from that point?
I was not dispatched.
Were you sent to any location from that point?
I was assigned with taking a number of investigators with myself and walking the entire parade route, going from establishment to establishment, bar to bar, restaurant to restaurant, and obtaining phone numbers and names of people who were present at the parade and who had witnessed something and would be followed up with later by a member of the Detective Bureau.
So it would be fair to say you did some interviews at that time?
Yes.
Do you recall how many?
No.
And after conducting these interviews, what did you do?
I went home.
So at that time, after conducting your interviews and then going back to your home, did you have the name or ID of any suspects at that time?
Yes.
And whom were you told by?
I don't recall.
Do you recall who you submitted your typed report to?
I don't understand your question.
Do you recall who you submitted your typed police report to?
No.
I'm assuming your law enforcement agency doesn't type up reports and just leave them sitting on the desk. Would that be fair to say?
That'd be correct.
Any reason why you wouldn't recall who you gave your report to?
Well, it's electronically submitted.
And from there, does it have a specific sergeant or lieutenant or captain or someone that it goes to from that point? If you recall, or if you know?
I wouldn't know.
So it'd be fair to say, once you type a report and submit it, you're not sure who sees it?
Correct.
Would you say it's fair that because of you not knowing who your report is submitted to, that your report can be altered in some kind of way? Especially being that you don't know who sees it?
The reports are done via PDF style reporting. It's protected by my username and my password. And when it's submitted, it's usually not altered unless I request it to be altered.
But it is fair to say that there's a possibility that it could be tampered with because you don't know for sure who all sees it.
It's entirely inaccurate.
How so?
My report is accurate. Right? My report is the way that it was written, the way that I wrote it myself.
So you've had a chance to read your submitted report after you submitted it?
Yes.
And to the best of your knowledge, is exactly word for word as you remember typing it?
It is my report. It is what I typed, and it is accurate.
Word for word?
Yes.
Do you recall how many pages long the report was?
Objection, relevance.
Grounds.
Sustained. Not relevant. Please move on.
Do you recall if the report was lengthy?
Objection, relevance.
Grounds.
Sustained. Next question, please.
Grounds for the sustain.
Relevance.
And you stated that you read the report after you submitted it. Do you know how long it was before you were able to see the report that you typed?
Objection, relevance.
Grounds.
Sustained.
Well, he already answered that.
Then I'll object as asked and answered, Your Honor.
Sustained.
That question wasn't answered, but okay. I see. Do you recall when you typed your report?
Objection, relevance.
Grounds.
Sustained. Not relevant.
How's that not relevant if he already answered that he typed a report?
Please continue, sir.
Grounds for the sustain.
Relevance.
He answered that he typed a report. So how's it not relevant if he recalls when he typed it?
Please continue, sir.
You got to be kidding me. Did you file any claim related to this matter?
No.
Do you know of anyone who did?
Did what?
Do you know of anyone who filed a claim in relation to this incident?
No.
Do you know who the plaintiff is in this incident?
Objection,
Grounds.
relevance.
You may answer that question. Go ahead.
Can you ask the question again?
Do you know who the plaintiff is in this incident?
Well, plaintiff would be the state of Wisconsin.
Is the state of Wisconsin a human being or an entity?
Objection,
Grounds.
argumentative.
Sustained on relevance grounds.
Have you ever had any interaction with the plaintiff in this incident?
Objection.
Grounds.
Relevant, legally inaccurate.
Grounds.
Sustained as to the form of the question.
Were you ever contacted by the plaintiff in this incident?
Same objection.
Grounds.
Sustained as to the form of the question.
Would you call the state of Wisconsin a living, breathing human being or
Asked and
entity?
answered.
Grounds, because I didn't ask that question.
It's not relevant. Sustained. Next question.
It's very relevant. Seems like there's no plaintiff.
Jury will disregard statements made by the attorneys and the parties. They are not evidence. Please
Stop
ask
trying to
the
be
question.
So to your knowledge, the plaintiff is the state of Wisconsin. Do you see him present in the courtroom today?
Objection, irrelevant.
Sustained.
Can you
relevant.
identify the plaintiff state of Wisconsin?
Same objection.
Grounds.
Sustained. Sir, please continue and not on this topic. Next question, please.
To the best of your knowledge, you're not even sure if you've ever even had any interaction with the plaintiff state of Wisconsin, correct?
Objection, argumentative, and compound.
Grounds.
Sustained.
Definitely wasn't compound. Would you consider yourself an injured party in this incident?
Objection,
Grounds.
argumentative.
The witness may answer.
No.
Have you read or seen a complaint?
No.
No further questions.
All right, thank you, sir. Any redirect?
No, thank you.
All right, thank you, sir. You may step down.
Detective Rowe should be dismissed, please. And yes, could we get the exhibit?
Yeah, why don't you grab that exhibit and take it? That one has the exhibit sticker, correct?
Yes.
All right, we can keep it by the state for now, and then later on it can be brought over to the clerk. All right, the state may call its next witness.
Is there a call? Speculation.
We want to bring you a live report from outside of the courtroom. Fox 6 News reporter Sam.
Never has been, never will be.
Fighting back tears, Brooks again argued what happened at the parade was not intentional, referencing witness testimony.
To do so. Your objection is noted for
Is the audio on?
Your objection is noted for the record.
Is the audio on?
Yes, it's on, sir. It's on.
So we're not going to address subject matter jurisdiction that has yet to be proven for the record.
For the record, I have addressed it.
No, you haven't
And
proven it
there's
for
a
the
written,
record.
and your objections noted for the
Have
record.
you proven subject matter jurisdiction for the record? Have you proven it? Has the prosecution proven it?
Oh, okay. Email that to her and print it out.
So that's a judicial determination that you don't have to answer that, Your Honor, being a public servant?
I was talking to my clerk. I didn't hear what you asked. The jury's coming in.
You heard what I asked.
I actually did not.
Come on, Your Honor. Come on now. Come on now. We got to cut that out. You know you have to prove subject matter jurisdiction. You know that. You have to honor your oath of office. You know that.
Thank you, everyone. Please be seated. The defense may call its next witness, please.
Give me 1 second. I'm trying to make sure I got the paperwork since I'm being rushed to judgment. That's not right. Oh, there you go. All right.
Go ahead.
Defense calls Erica Patterson.
Great, thank you. We'll have her brought in.
Since I'm being rushed to judgment.
Good morning, Ms. Patterson. If you would please make your way to the witness stand, which is on my right. You may recall it's upper riser. When you get there, please remain standing. Raise your right hand, and my clerk, Teresa, who's across from you and on my left, will swear you in.
Do you solemnly swear that the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth, so help you God? Yes.
Thank you. Please be seated. First thing I will ask you to do is to state your first and last names for the record.
Erica Patterson.
Thank you. Go ahead, your witness.
Oh, the one spelling the name?
I believe it's on the record from previously, but go ahead. You can spell your first and last names, please.
ErikaPatterson.
Just 1 second, Your Honor. I'm trying to find some relevant paperwork here. sorry about that. 1 second, I'm trying to find this paperwork. Just had it on the table.
When you're ready. Did you print that off for me? Did you email it to me? It's still not here. I'm like, what's your name? Did you spell it?
I'm just gonna start the questioning. I'm not seeming to find paperwork that I just had on the table for some reason, odd reason. Good morning, Miss Patterson.
Good morning.
So, what do you do for a living?
I have my CNA certificate.
I'm gonna direct your attention to the evening of November 21st, 2021. Do you recall what you were doing that evening?
I was hanging out with my friend Corey at Frame Park. I had spoken to you, Mr. Darrell Brooks. You came out there at Frame Park and met me after Miss Corey separated from me with her friend. Me and you got into an argument.
Whoa. Pursuant to the question?
I am answering your question.
I was referring to the judge.
I was hanging out with
I think
Miss
I kind
Corey.
of got a little ahead of.
Oh. Mr. Brooks, just, I'll let you interrupt the answer and you can ask a follow-up. I apologize, I was instructing the clerk to turn up the volume. So go ahead, ask your question.
Same question?
Sure.
What were you doing the evening of November 21st, 2021 before linking up with the alleged defendant?
Hanging with my roommate at the time at Frame Park.
And what were you and your roommate doing?
I'll object. We covered this ground during her testimony previously.
Objection and grounds for, I object to that and grounds for the objection on behalf of the state.
Mr. Brooks, we did cover many of these topics previously, so if there's new topics, please go to those. I'll give you a little bit of leeway to lay some foundation, but go ahead, ask your question.
That's
the
with
objection is from the state is overruled. Do you remember the question?
You asked me what was I doing at the park with Corey? Is that your question?
Yes.
We were drinking. I was drinking Mike's Hard beverage.
Do you recall around what time of the evening it was when you and your roommate arrived at the park?
I do not remember. We left where we were staying a little around afternoon. A little bit around afternoon.
Do you recall Do you recall having any phone interactions during that time when you and your roommate were at the park?
Phone interactions, yes.
Do you recall who they were with?
You.
What do you mean by you?
Daryl Brooks.
Is that usually the name you refer to the alleged defendant by?
Nope.
Would it be fair to say that during those phone interactions, there was a talk of you guys meeting up? Would that be fair to say?
Yes.
Do you recall, to the best of your recollection, what time that would have been at?
No, I don't remember. It was throughout the day.
I'm sorry, are you making references to the phone conversations being throughout the day?
Yes.
And so at some point, would it be fair to say that you did meet up with the alleged defendant?
Yes.
Do you recall what time that was?
I just told you no.
Do you recall if you were still at the park during that time, or had you moved locations?
Still at the park.
And was your roommate still present with you at that time?
No, she left. We went separate ways. I stayed at the park, and she went her other way with her friend.
Do you recall who that friend was?
Nick.
I'm assuming, or let me back that up. Would it be fair to say that at some point during the meetup with the alleged defendant, things got a little chaotic? That'd be fair to say?
Yes.
And do you recall if at that point you were still at the park?
When we met up?
Yes.
Well, we were at the park for a second, then we drove around.
Where did you drive to?
Around, then me and you, Mr. Brooks, were arguing in the car. We went up this is a street, it's like a hill. Went up there, and then me and you got into an altercation. I got out of the car, walked back towards Frame Park.
Wait, again.
Hold on, she's answering your question. You asked her where you drove around. Go ahead and finish.
Yes, ma'am. And then I was walking down the street when I left your car. And that's when you followed me, and I walked back towards Frame Park, and you were following me.
Made reference to walk back to Frame Park.
I don't know the exact street name. It was I walked back down the hill. I don't know the exact street name.
Did you at any time, sorry, did you at any time during your travels back to Frame Park, did you at any time notice that there was something going on in the area?
No. When I got to Frame, I was too worried about walking back to Frame Park. When I got to Frame Park after I left it, that's when I realized there's something going on.
And did you ever arrive back at Frame Park?
Yes.
And what did you do when you arrived back at Frame Park?
I called my friend Corey and told her that me and Mr. Brooks got into an altercation. Mr. Brooks was following me. I went back to the SUV, the car, and you argued with me somewhere. I walked back across the street, and by that time, Miss Corey had walked towards us to meet up with me.
And you made reference to you calling your friends.
Mm-hmm.
Do you recall? Well, let me back up a little bit. Did you call your friend Corey or the friend that she had left you to hang out with?
Corey's phone, I kept calling her phone kept going to voicemail, so then I called Nick's phone. He put Corey on the phone and said Daryl Brooks had just hit me.
I'm going to back up a little bit, if I may, to the day prior, November 20th of 2021. Do you recall what you were doing that day?
Well, where I was staying at the shelter at first, I was arguing still with Mr. Brooks all throughout the day. Me and Corey had left, and Corey and I stepped away, and I went back to Frame Park. To Frame Park, that's where I met you at. Me and you also got into argument that day, but we didn't drive around. We're at the Frame Park.
So you're saying that you and the alleged defendant were together the day of November 20th, 2021?
Yes.
Do you recall around what time that was?
I do not remember.
And you stated you were briefly with your friend Corey that day?
Yeah, but she went a whole different direction. She didn't come to Frame Park with me. She turned on a whole different street right before Frame Park.
Do you recall at any time on November 21st of 2021 being interviewed by a Detective Guth?
Yep.
And do you recall giving a recorded report at that time?
I don't remember.
Do you recall if you had given Detective Goof all the details of the alleged incident on November 20th of 2021?
I didn't give him all the details, but I did the next day when I seen him.
Funny. Were you aware that it was reported there was in fact no incident on November 20th, 2021?
That's not true.
Objection. Move to strike the answer and the question.
Grounds.
Lack of personal knowledge. Hearsay.
Sustained. I'll strike the question and the answer. The reason stated, sir, rephrase, or...
So can I show the witness that same paperwork that I attempted to show?
No.
And why not?
Not relevant.
How's it not relevant when that was just testified to? Wouldn't that be opening the door?
No. Next question.
Any reason why it would be reported no incident happened on November 20th of 2021?
Same objection.
Grounds.
Some facts not in evidence. Sustained.
Grounds for the sustain?
The record speaks for itself.
So, upon speaking to Detective Goof during the first interview, do you recall why you were not forthright with information?
It wasn't that I was not forthright, I just didn't tell him everything right away.
Why not?
I don't know, Mr. Brooks.
When speaking with a law enforcement officer, would it be fair to say that you should be truthful and honest?
I was very truthful. I just didn't tell him everything at once. I told him the next day, Mr. Brooks.
And in the alleged incident on November 20th of 2021, were you injured?
No. Well, you did hit me a little, like a little.
Were you injured?
No, I didn't have any marks on me. Is that what you're asking?
So where were you injured?
By my lip.
Objection. This states the evidence.
Grounds.
I believe the witness understood the question. She answered it. It may stand.
Did your roommate observe any injuries from the alleged incident on November 20th, 2021?
She knew about it, but there's nothing visible on my face.
Do you know if your roommate had spoken with law enforcement about these alleged incidents from November 20th of 2021 and November 21st of 2021?
I don't know.
Did she ever tell you yourself that she was interviewed by any law enforcement?
I don't remember.
One second. So what time did you meet up with the alleged defendant on November 20th, 2021?
I don't remember.
Was it morning time?
Afternoon.
Time? I didn't hear that.
Afternoon.
And what were you doing prior to the alleged meeting up with the alleged defendant?
Objection.
Grounds.
Asked and answered.
Sustained.
Grounds for the sustain.
Asked and answered.
When?
Next question, please.
When was it answered? So to the best of your recollection, you can't recall why an alleged incident on November 20th of 2021 was reported to never happen.
Objection.
Grounds.
Same reasons as the previous objections.
Assumes facts not in evidence. Mischaracterizes her prior testimony and irrelevant.
I object to that respectfully and
Next
ask
question.
for a legal finding of fact and a legal reconsideration of that ruling, Your Honor.
Denied. Noted for the record. Next question, please.
I'm trying to figure out how something got pulled out of thin air. Interesting. So it would be fair to say that you have a child in common with the alleged defendant. Would that be fair to say?
Yes.
Is that the only child in common?
Yes.
You have any other children?
Objection.
Grounds.
Has nothing to do with the case. Sorry.
Hold on, there's been an objection. Not relevant. Sustained.
Grounds for the sustain?
The record speaks for itself. Next question.
What was the record speaking for itself? I didn't hear it.
Not relevant.
How is it not relevant?
Next question, please.
How is it not relevant? The child that you have in common with the alleged defendant, how old is that child?
15.
Do you keep regular contact with that child?
Off and on.
Describe what you mean by off and on.
I'll object.
Grounds.
This is not relevant.
Not relevant. Sustained.
Grounds.
It's not relevant, sir.
She answered it.
Next question, please.
And the child in common that you have with the alleged defendant, does that child live with you?
No.
Objection.
Grounds.
Relevant.
Sustained. Not relevant. You don't have to answer that.
Do any of your children live with you?
Objection.
Grounds.
Relevance.
Sustained.
Grounds for the sustain?
Not relevant.
That goes to the credibility, Your Honor, so how is it not relevant?
The objection has been sustained.
For relevancy. I object to that and would like to inform you that I intend to appeal that decision unless you want to give a legal reconsideration of that ruling.
Noted for the record, I direct your attention to 906.16, and the basis for the objection being sustained is it does not fall within the categories listed. Next question.
Is that lawful law?
Next question, please, sir.
I'm getting there. This is lawful law.
Wisconsin State Statute 906.16.
That doesn't answer my question, but okay. Where did you meet the alleged defendant?
Reno, Nevada.
How long have you known the alleged defendant?
16 years.
You made reference to meeting in Nevada. Do you recall where you met at in Nevada?
No. I don't remember.
In relation to the alleged incident on November 21st of 2021, would it be fair to say that there's been no contact between you and the alleged defendant?
Not since then, no.
That last answer was kind of low. Did you say no?
I said no, not since then.
So that would mean, assuming, that would mean no contact at all via phone or anything like that?
No.
So my question would be, I don't know if you can see them from here, but do you recognize these pictures?
You need to show those to the state. The bailiff will take them. That's not proper procedure, sir.
I'm going to object to those being shown to the witness. They have no relevance whatsoever to this trial.
Yes, they do.
Sustained.
And I'm getting to how they have relevance.
They've also never been disclosed to the state before this moment.
Sustained.
Sustained why?
Not relevant.
They are relevant. It creates foundation. And I can prove that.
I'll take up the issue outside the presence of the jury at the conclusion of this witness, and if need be, bring the witness back in. But next question, please.
And these need to be offered into evidence as well. You stated that there's been no contact. How would the alleged defendant obtain photographs from you if there's been No contact.
Objection.
Grounds.
Assumes fact, not in evidence.
Grounds.
Sustained. Assumes facts not in evidence, not relevant.
How's it not relevant? Photos just don't pop up out of the blue.
Mr. Brooks assumes facts not in evidence,
No,
and at
facts.
this point,
I got the pictures
conduct
right here.
after
Facts.
the alleged date of violation here is not relevant.
Alleged violation.
You're
For the record.
correct. After the date charged, that the dates that are charged for these allegations, you are absolutely correct.
Thank you. Have you, since the evening of November 21st of 2021, have you attempted to contact the alleged defendant?
Objection.
Grounds.
Relevance.
Grounds.
I'm going to excuse the jury. I'll rise for the jury. Think you be seated?
It's awful funny. Your Honor, I find it.
Hold on. All right, sir, I'm going to let you make an offer of proof as to why you believe the photographs and the questioning about contact after the alleged incident is relevant.
It's relevant because these were sent by the witness.
It assumes a fact, not an evidence, but
You
what
want
is...
the letter
hold
too?
Hold on. Tell me the basis you believe there's been communication and why you believe it's relevant to her testimony.
It's relevant because it was testified to her first time testifying, and then also by was the last guy, Guth, that he was told that the witness was supposed to be so deeply afraid of me and all this type of stuff. So if you're so deeply afraid and worried about somebody and this and that, why would you speak and have
Do you want
contact?
to open up the door to the other act's evidence of
That's
you?
not opening.
No.
That's not
Hear me
opening the
out.
door.
Hear me out. Oh, yes, it does.
No, it doesn't.
These witnesses have been incredibly careful to abide by my rulings. Sometimes in a court of law, when there are pretrial rulings, the testimony of a witness needs to be said in such a way not to run afoul of that. This witness, Detective Guth, I believe Detective Casey and others, Corey Runkle, and even Nicholas Kirby yesterday, this court has all had to stop them so that they didn't run afoul, or they've stopped themselves so that they didn't run afoul of the court's pretrial ruling on other acts evidence between you and this witness. And I have been very, very careful to make sure that doesn't come in. But if you keep questioning her about whether she's afraid or not, or why she wouldn't have contact or not, you are opening the door to that testimony. All of my rulings have been made to prevent what could be seen as prejudicial evidence. The standard's not prejudicial. The standard's whether it's unfairly prejudicial. But you can open the door to that, sir.
It's unfairly prejudicial that I have a document stating that November 20th never even happened, but yet and still the witness can get on the stand and lie on the stand.
Have you turned that document over to the state?
Come on, man. Y'all know that's not right. Y'all know that's not right.
Then you need to immediately turn it over to the state right now. It may become relevant, but no one has seen it. When did you receive the document? Hold on. When did you? I'm having you make an offer. When did you receive the document?
Okay, but I just want to state for the record, Your Honor, that's kind of biased because the state did the same thing yesterday with creating an exhibit right on the fly that didn't even exist that I didn't have. But
that's not true. That's a misstatement of the
that
evidence.
Is true.
No,
she said it herself.
No, marking an exhibit is not creating an exhibit.
No, not marking an exhibit. She said
we're not going to go down a tangent, sir.
Right,
I'm going to focus on this, and I'm going to give you the opportunity to make a record.
It's not fair. It's not fair.
When did you receive this document that you claim was sent by this witness?
It's not claim. It's for a fact.
Sir, it hasn't been established yet. I need to make a record.
So y'all want the letter?
I want to see the letter.
What?
I want to see the letter.
Okay, so I got.
And I want to know when you received it.
I got to bring that in. Every time, this is what I don't get. Every time I'm presenting something that needs to be made for the record and placed in the evidence, it's a problem. But the state can do it, no problem.
It's not, sir. There are proper procedures, and I want you to make a record. If you don't make a record, then I can't make a ruling.
It threw people off a loop. They weren't ready for it. They scared of it. That's what it is. Come on, man.
Mr. Brooks.
Come on, man. Stop.
When you aren't even letting
You're a public servant, Your Honor. I respect your courtroom. I respect you. You're a public servant, though. Your job is to be the referee. Is it or is it not? You stated so yourself on record that your job is being the umpire.
Your Honor, can I ask Ms. Patterson please be excused?
Yes, you can be excused. My apologies.
My apologies too, but it needs to be some truth. Especially when we're talking about stuff that didn't even happen, but they're allowed to get on the stand and say that it happened when they know it didn't happen.
So I'm going to make a record about what he's referring to in count 77. Okay.
And what happened to that paper? Because it was on the table. Then when I come back in,
I need to make a record of a variety of things.
So who took my paper?
And you keep interrupting me repeatedly today. I have shown an abundance of patience this morning. I've warned you repeatedly about being removed from the courtroom. And then every time I try to get into it, you, meaning an explanation and make a record, you interrupt, you attempt to divert everyone from what is being done this very second.
I didn't attempt to do anything.
Yes, you do it repeatedly,
okay,
sir.
Whatever.
So you're doing it once again.
Whatever. Just make your record.
The document that Mr. Brooks wanted to show Detective Guth and this witness was a letter sent from the state of Wisconsin to the court regarding count 77. The state sought to dismiss that count, and they have prosecutorial discretion, and I granted the request that the charge be dismissed.
Why was the charge dismissed?
And that's, I can't answer. It was dismissed because the request was made, sir. They don't need a reason. There's an abundance of case law about prosecutorial discretion. And they chose not to pursue that. My guess is maybe to simplify things and to keep this tidy. I don't know. You know what? I'll indulge you. Attorney Opper, would you like to provide a basis for why the state sought dismissal of that charge prior to the start of this trial?
Yes, Your Honor, because as Ms. Patterson just testified a short while ago, she did not have any visible marks or injuries from that event. And we did have the photographs of her injuries. We did not want to confuse the record as to whether or not there was a battery that occurred on November 20th.
Your Honor, I object to that. What does the letter read?
You have the letter. You showed it to me, sir.
And I've been trying to find it ever since I came back in here. And now all of a sudden I can't.
And now you're impugning, though, like somehow you're impugning the integrity of this court, of the bailiffs of this state. You're accusing, frankly, everyone of moving your papers.
Did I point the finger at anyone? Did I say anyone did anything?
Not directly, but indirectly you did,
So
sir.
how can you make the assumption that I'm saying?
Can I please make the record without you interrupting me?
Yes, you may. Yes, you may. I apologize.
I appreciate that. Thank you. But you made repeated comments, sir, about I can't find my documents, I don't know what happened, things of that nature. When you came back out, you took multiple minutes before you even asked your first question of Ms. Patterson. And if I need to, I'll have a bailiff put on the record that no one touched your table.
Your Honor, did I say anyone touched my table? I didn't say
you implied it, sir.
But did I say that?
You stated it implicitly.
I never asked the bailiffs, hey, did any one of you touch my table? I never said that to them. I just said I can't find my paper, which is the truth.
And the way that you said it, like,
I didn't point anyone out, though.
And like, well, that's kind of interesting. I don't have a document that was just on my table. That is what you said.
That's what I said, but I did not point the finger at anyone.
So,
I
you
can see
have
if
the
I
letter.
came in, Your Honor, with
You've
all
been
respect,
given.
I can see if I came in and said, hey, one of you moved something off my table, or if I would have directed that towards the state, or if I directed that towards the clerks or something like that, then that would be more of a validity to what you're saying.
I need to continue with the record, sir. It's very apparent to me, sir, that every time, I can't say every time because that would be an absolute, but many times throughout this trial, and especially the last 2 days, when the court makes a ruling that you disagree with, or I want to make a record about some behavior of yours, or a further record about a ruling that you that was not in your favor, that you start peppering me with questions or comments, statements. You question me about the law. You ask, is it verified law? It is, from my perspective, a clear attempt to kind of turn us in a direction away from what we're doing, perhaps even to stall and to delay.
I'm sorry.
That's my perspective. That I'm making a rule. You're doing it again.
I mean, because it has no validity.
So, I am trying to make a record outside the presence of the jury about a line of questioning you want to ask Ms. Patterson. Now, I've reviewed repeatedly up on the bench 90608 and 90616, which are two of the primary ways you can attack credibility. I've referenced one of those previously. 90608 is evidence of character and conduct of a witness. I'm not going to read through it all, but it's limited to character for truthfulness or untruthfulness. It's not specific instances of conduct. It's character evidence, which frankly wouldn't even come from the witness who's testifying. All right, then there's the statute on bias, 90616. All right, and none of the questions as I heard them went to a permissible topic under bias of witnesses. You generally said credibility. You did not give me any further explanation as to why you believed it was relevant to credibility. Now we have you claiming that there's some document that was sent by the witness after the charges were filed that apparently contained photographs. I think, and you can clarify the record momentarily when I'm done, that you believe goes to the credibility of this witness. So I need to ask a few questions about that, sir, to determine whether it has relevance to those issues. Number one, when did you receive this letter?
I received this multiple letters, actually, over a period of time. It wasn't, I referred to this one because this one had the pictures. But
and why do you believe it was from Ms. Patterson?
To answer your question with clarity.
Thank you. Does it have a date on it? The letter?
No, I didn't bring the letter. I brought the pictures. Because I thought, from my interpretation, I thought showing the pictures would be okay. How did I get these? So my mind was saying, show the pictures. They didn't come out of thin air. The witness knows that they sent me the pictures. They know that.
Well, again, it assumes facts that aren't here. You're assuming this witness sent it. I don't know. But even if she did, what relevance does it have to her credibility before this jury?
It goes to the credibility because she's put on this facade of being so afraid of someone, but yet still, you know that we're not supposed to have contact, but you still sneaking behind and saying, oh, I wonder how you're doing, and oh, this and this and that. Oh,
I don't think she's ever said she was afraid. I think that was the officers who may have stated that, but I don't believe she ever said that. She specifically said today, when you asked her why Did you, it was either why did you go back or why did you have, I'll look at my notes, and she said, I don't know.
It was why weren't you forthright with all the details? That was the question.
So again, I'm going to ask you, even if this letter's from her, these pictures are from her, how does it relate to her credibility before the jury?
Who else could these pictures be from?
I'm going to ask you point blank, did you get a letter that's signed from her?
What do you mean signed? No
How do you know?
letters.
What's your why do you have a belief that they are from her?
I have multiple letters from her.
You're not answering my question. Why do you believe the letters are from Erica Patterson?
Because they were sent from Erica Patterson. Why else would I?
Were they signed by her?
What do you mean signed?
Did she write her name on the letter? Was it the content of the letter? No, I'm not kidding you. I need to make a record, sir. You're making a statement that these letters are from her and that they're relevant to her credibility.
Your Honor, I'm going to go out on the limb here.
And I'm asking you why you hold that opinion.
I'm going to go out on the limb here and assume, which I know is true, you've never been in my position. You've never been in jail. So you've never received a letter from someone writing someone in jail. No one is going to... When you
You're
say
not
to
answering
me,
my
when
question,
you say to
sir.
me,
What's the basis why you believe they're from Miss Patterson? Is there some information in them that only she would know? Did she sign the letters? Is it penmanship that you recognize? Why do you believe they're from her as opposed to somebody else sending you information? Could be your mom, could be, I'm just saying, could be anybody else. You got to answer my question. It's called an offer of proof.
But you still got to understand why this is mind-boggling to me. Like, how I got a child with this woman. Why would I not know her handwriting?
But you have to lay a foundation for these letters, sir. That might be through your own testimony. So that I'm trying to figure out why you believe they're from her. Not all this other stuff about I'm in jail and I have a child. I'm trying to I need to know. It's called an offer of proof.
Are you serious?
What do you believe? Why do you believe they're from her? I am serious.
Because they're from her.
But you're assuming.
Like, how else am I supposed to answer that?
I've given you a few reasons why it would lend to that opinion.
So it has to be put in a legal term.
The bottom line is I need the letter. So if you're going to question her on that, the state absolutely has a right to see the letter. So you need to provide that letter. The bottom line is I'm not going to allow any questioning without having that letter. So the state has the ability to question you about that or question this witness and to look at the veracity of what your claims are here. So I may take an early lunch. If that's in your cell, then you can go get it and bring it. But without that letter, I'm not allowing this line of questioning. Do you have the letter with you in court?
I just said no. How many times I got to say the same thing on record?
You know, sometimes, sir, I don't hear what you say because you interrupt me so much or you answer quietly. And I'm taking notes and I'm focused on probably a dozen things at the same time.
But if I say something under my breath, everybody seems to hear it. Everybody seems to hear that just fine.
In a quiet courtroom, yes, we can hear it very clearly.
Everybody assumes that it has to be disparaging.
Once again, you're doing this tactic.
Because it's not a tactic, it's facts.
What we're talking about to some other reason.
It's facts. Because I find it hard to believe that
I'm gonna
all of a sudden nobody hears what I say.
I'm going to let the state make a record of why they believe it's objectionable because I haven't let them do that. I've given you multiple opportunities to tell me why you believe it's...
I didn't get these pictures from nobody else. Why was somebody else...
The record will reflect you have 2 pictures that you believe were from this witness.
That I know is from him.
No, that you believe.
That I know.
All right. I'll ask the state their position on all of this.
My position, Your Honor, is that these pictures, first of all, should not be admissible. 1, because of a discovery violation. We've never seen them before. 2, because we have reason to believe that he did not get them from Erica Patterson. He is on a jail phone call talking to his mother, Dawn Woods, about Dawn Woods sending these photographs to him. Now,
that's a lie. I object to that.
Let the state make their argument without interruption, sir.
That's a lie, though.
3, I believe that these photographs are designed to make a suggestion to the jury that Erica Patterson is a bad mom. I think that is what the defendant is trying to do. And if we're going to go down that road, then we would be forced to counter that claim. First of all, it doesn't make her an incredible witness, if it's even true. And second of all, if we go down that road, we would be forced to counter that claim by pointing out that not only does the defendant not live with the child in question, he doesn't live with any of the other children that he has. He impregnated Erica Patterson when she was a minor in Nevada, and for doing so, he was convicted of statutory sexual seduction, pled guilty in March of 2007 to that felony offense, and is a sex offender on the registry as a result. So if there's any causation that would lead to Erica Patterson being a bad mom, Mr. Brooks has a direct role in that causation.
And that's
furthermore,
I object to that.
I'm not
because that's a lie.
Let him
Because at the
finish.
end of the day,
Let him finish,
if we gonna open the door
Mr.
on that, no,
Brooks.
since he want to make a record and not be accurate, so let's be accurate all on the record. Since you think you know so much,
Once
so
again,
we can
Mr.
open the
Brooks
door
is
on.
being
We can
loud,
open the door on how old she told me she was when we met.
interrupting.
We can ask
He's-
that question
he is
too. Then
over the
Did you
top,
ask that?
animated
Do you
right
know
now.
that?
Mr. Brooks, I'm ordering you to sit down and to let the state
No,
finish.
no, I'm not going to sit here and let somebody be inaccurate on the record and lie on the record.
Right. Under Illinois versus Allen, I've warned him repeatedly. He's being removed from the courtroom. And you know what? Let me dial that back. We're just going to take an early lunch, 1 hour. We'll be back. And unless he brings that letter and he can show it is inadmissible, she will not be questioned. And under 906.11, I will declare the cross-examination closed. Thank you. We're in recess. 1 hour.
Get your facts straight. So let's open the door on all of it then, so we can get all of it on the record. Since you think you know so much. Did you know she said she was 18 when I met her? Did you know that?
As to this particular piece of evidence only, Mr. Brooks, you may ask questions of Detective Casey.
Objection, I don't consent to being called that name. And yeah,
Noted. Do you have any questions for the witness?
This, when did this video, when was this made a exhibit? Because I don't have it.
Objection, that's not a question for the witness, Your Honor.
That was a question.
Sustained. As to the form of the question,
when was this video made an exhibit? That is a question.
I object to the question directed at the witness, Your Honor. It's beyond the scope of his knowledge.
Well, he said he saw it.
But that's not the question asked. So you can rephrase your question if you want to.
When did you see this exhibit? When did you see it?
With the understanding that you're asking when did he see the video, I will allow the question to be asked.
When did you see this exhibit?
With that understanding, you may answer Detective Casey.
Am I answering when I saw the video for the first time?
Yes.
Objection, Your Honor. Why is something always funny at that table? It would be the same thing. I take that as disrespect because they were allowed to say something and I said under my breath that was disrespect.
I would direct both parties to avoid commentary.
Okay, well, can you do that, please, and admonish them? Because I'm always the one getting admonished.
Everyone.
I take that as disrespect too.
Sir, can I do my job? State's directed to avoid laughing commentary. I didn't see it, so I can't further comment. I was looking at
all these
the
cameras
witness.
in here. Don't nobody see nothing.
I'm advising both parties to show decorum
this is not fair.
and restraint, to be respectful of this jury's time and attention, and to let them do their job by focusing on the testimony and exhibits and evidence that's presented. Go ahead, Detective Casey. You can answer the question about when you have seen this video prior to today.
I saw the video within a few days of Mr. Brooks being arrested. I've reviewed it since then a few times. I reviewed it yesterday and again this morning, and now in court again.
You said you reviewed it yesterday and this morning. If you had seen this video numerous times before yesterday and today, why did you feel the need to view it yesterday and today?
Objection, argumentative.
Grounds.
Sustained as to the form of the question.
Why did you need to review it this morning?
Objection, argumentative.
Overruled. The witness may answer.
Because I wanted to be 100% sure of the content, and if there's any questions that were asked of it, I wanted to make sure that I would be able to answer them appropriately.
And why was this, to your knowledge, why was this video never brought up in your earlier testimony?
Objection, that's a misstatement, Your Honor.
Sustained
It was
as to the
not
form
brought
of
up
the
in
question
his
assumes
testimony.
facts not in evidence.
If you had seen it numerous times before today, why did you need to see it again to make sure if any questions were asked, or however you refer to it? What would be the need to view again this morning something that you had viewed numerous times before?
I will say with my
Objection, compound, asked and answered, misstatement of the facts, argumentative.
Sustained.
Did you view the video this morning because you knew that the video would be made an exhibit this morning?
Objection, assumes facts not in evidence.
Sustained as to the form of the question.
This is mind-boggling. This is mind-boggling. Can you clarify again why you viewed the video this morning?
Objection, asked and answered.
Sustained.
So you're going to sustain everything?
It was already answered, sir. Next question, please.
And I'm asking for clarification.
Next question, please.
I don't got no more questions, man.
All right. Thank you.
This is mind-boggling.
Detective, you may step down. I'll excuse the jury.
What you people is trying to do is not fair. Hide things from the jury repeatedly. You don't tell them all the information
Mr.
they
Brooks,
need
I'm
to
going
know.
to take up all of your objections outside the presence of the jury. I'd ask that you honor my decision to do that and you show courtesy and decorum.
Because you asked.
Mr. Brooks, please.
Because you asked. That's the only reason, because you asked. I see what you people are trying to do. It's not right. It's not fair and it's not right.
You can have a seat. Well, once the jury's outside of the courtroom, I'll take up the objections previously in the evidence. All right. First of all, Attorney Opper, if you can make a record as to this exhibit and whether it's been turned over previously.
It was previously included in the initial discovery that was sent initially to the public defender's office, and now we have a record that those 3 boxes were turned over to Mr. Brooks.
Objection, I don't consent to being called that name, and it was not in the video footage that I have obtained. That video was not part of it. Do you think I would sit here and be this irritated?
Mr. Brooks, I need to make a record, so just please sit down. There's no need for you to stand at the moment.
I feel like standing right now.
Please sit down.
I feel like standing.
All right, based upon the offer of proof provided by the state, and it was provided to prior counsel, that satisfies me as to that issue. I indicated I would.
That's inaccurate, Your Honor. Can we have the prior counsel testify to that then? Because
not at this time, sir.
I have not obtained that. Right now, that was my first time seeing that as an exhibit.
Mr. Brooks, I presume, and you can correct me if I'm wrong, but you're familiar with that video? Yes or no?
What does that have to do with what we're talking
Because
about?
I'm going to make a finding based upon what I viewed in that video, that there is absolutely no surprise to you. It appears to me, even without the video, that that's a music video, that you are in it, that the vehicle that has been the subject of this entire case, that red Ford Escape with the plate that's been testified to, is in that video. That video is relevant for a number of different reasons, the first of which it goes to identification of you, identification of the vehicle. You opened up the door through your cross-exam of Detective Casey about his ability to identify you in that video. And when I say identification of you, specifically as it relates to Detective Casey's opinion that that's you in the video, of course, it's ultimately up to the jury to determine that and what relevance, if any, that evidence have. But You opened up the door for the state to show that video because you directly attacked the credibility of Detective Casey through his knowledge of it and the identification by him of you in it because the still image was of your back.
Okay.
So that opened up the door, and it's proper. There's absolutely no surprise to you that that video exists, and that is my finding as it relates to that.
What do you mean by it's no surprise to me that it exists? That was not the issue. The issue was how was it made an exhibit at the last moment? How does it be made an exhibit out of the blue? That was the issue. The issue
State can make an offer of proof on that because obviously they marked it as an exhibit.
But with all respect,
so go
Your
ahead,
Honor, you're
Attorney
mischaracterizing what I said, and the record needs to be clear. The issue that I raised was how does this, at the last minute, out of the blue, become an exhibit? That was the issue.
Go ahead and make your offer of proof on that.
Thank you, Judge. And another thing worth noting is the testimony of Detective Casey that this video was obtained from the defendant's own Facebook account as well. The court is well aware.
He said social media.
Nothing that.
He didn't say what it was.
Sir, stop interrupting. We have to make a record of it. You've interrupted multiple times. I've been abundantly patient with you. Again, another interruption. So you need to be quiet and let the state make a record. Stop gesturing at me. Stop rolling your eyes at me. Stop mumbling.
I'm looking right at you. I'm not rolling my eyes.
No, you have throughout. I've seen it and I've made note of it.
I'm looking at you. Okay, so are you asking me to be quiet or are you telling me to be quiet?
Go ahead, Attorney Opper.
Thank you, Your Honor.
I'm gonna take that
and
as
just to indicate, Your Honor, this court has been abundantly patient with Mr. Brooks. He challenges the court's authority repeatedly. This court absolutely has the ability to tell him, sit down and be quiet. And you haven't done that. And I know why you haven't done that, Your Honor, and we appreciate that. He is not in control of this courtroom. You are. And he needs to respect that. This video was relevant based on his questioning of Detective Casey, as you just indicated, challenging his ability to identify the person who had their back turned to the camera in the still shot of State's Exhibit 175. Trials are fluid. When he opened the door to that, we came up with the video which Detective Casey testified repeatedly on direct examination and cross-examination as to how he knew that was Mr. Brooks because he had seen the rest of the video. He would not accept that. He pushed it and pushed it and pushed it until we played the video. The lyrics of that video probably would have been prejudicial. Originally, I wasn't going to ask for volume. Then I did because he pushed it again, and his voice and his mannerism of speech, I thought would have assisted the jury in identifying Mr. Brooks as the person in the video with the red SUV. However, you smartly asked me to play it without the audio, and I did that, and then I never went back to that. This is all to the benefit of this defendant who continues to suggest and impugn the integrity of this court and this prosecution without basis. He doesn't like it because the evidence is stacking up and stacking up, and whenever it does, his response is to accuse you, the court, or the prosecutors of being unethical and hiding things. There is nothing in law that prevents me from pulling something out of my briefcase right now and making it an exhibit if it's relevant. You decide what's relevant, what's admissible, not Mr. Brooks. There is no law, he can cite to no law, no authority whatsoever that says I can't make an exhibit essentially on the fly if it's called for, and that's exactly what just happened here. So I apologize for my tone with the court. I don't mean to direct this at the court. It is very frustrating. The court has demonstrated much more patience than I have with Mr. Brooks because, again, I do not appreciate his impugning the integrity of these proceedings, of Your Honor's efforts to run a fair trial, and of our efforts to run a fair trial. We have ethical obligations as well to be fair in this courtroom. We have respected that entirely. The reason I was laughing 30 seconds ago was because the exhibit was mislabeled. There was an extra Y and it said Exhibit E, EXHIBITY. And I turned around to the paralegal and pointed that out, and we laughed over it, the word exhibity. That was it. There has been no disrespect directed at Mr. Brooks directly in any fashion. So he can object all he wants, and he has made that clear. He will continue to object and obstruct the court and obstruct these proceedings every last chance he gets. But legally, everything has been above board and proper, and this exhibit is no exception. I apologize for my tone, Judge.
Thank you. I appreciate that additional record being made.
I object to that.
My previous ruling doesn't change in any way that the exhibit is relevant. I indicated I would take it up because, and I'm taking what the state's saying as withdrawing the request to play the lyrics.
That is correct.
All right. I have not heard them, but I'll certainly take the state at its word as an officer of the court that it would be prejudicial based upon the lyrics that are in that video, but my decision to admit the video without audio stands. I do want to take up two other issues. There was an objection to questions regarding cross-examination, so the objections were by the state. One had to do with there was questioning about possible testimony with his niece and nephew, and then the jail cell search issues. So Mr. Brooks, you asked the questions. The state had objected. Since you're the proponent of what would presumably come in through the testimony of Detective Casey, what is your offer of proof as to why I should allow Detective Casey to come back on the stand and testify about his interaction, I believe it was with your mom, and possible testimony of your niece and nephew?
It don't matter with Detective Casey. He's off the stand. He's not going back on the stand.
No, but I told you I would recall him. I wanted to take it up outside the presence of the jury.
How do I supposed to know?
So are you withdrawing that, sir?
How am I supposed to know? I think I deserve a chance to rebut what was just said. I think I deserve that much if it's a fair trial.
What information do you want to provide to me about that last exhibit?
About what last exhibit? I'm talking about the audacity of the prosecution to just put that on the record when it's stated it's untrue.
I don't know what you're talking about. What's untrue?
We just heard her talk for 5-10 minutes straight. Now don't nobody know what I'm talking about.
I don't know specifically what you're talking about,
There's a reference made to what I'm supposed to know about the evidence stacking up and this and that, as if that has any bearing on what I still think and what I'm still going to present. It doesn't.
Well, that's not what we're talking about at the moment. I made a ruling on an exhibit.
She's been laughing and making comments under her breath the whole time during the whole trial, and I never said nothing. I don't know what's being said, but I can tell that it's directed towards me. I'm not an idiot.
I haven't made any of those observations,
I didn't
sir.
say
What
you.
I've observed,
I didn't say you, Your Honor.
No. What I've observed is
listen, please.
Go ahead.
For her to sit there and try to play it off as if she's not referencing to me, she must think I'm an idiot. That is very disrespectful to me. I haven't said anything about that until today. She's done it numerous times.
What are you talking about? I don't know what you're
laughing under her breath. Her trying to cover up the microphone so they can laugh and he and key. That they've been doing that the whole time. I didn't say anything about it.
I have not noticed that. What I notice are 3 attorneys who cover up the microphone so that they're not heard when they're conferring with each other about evidentiary issues or about testimony.
So why is it always laughing and giggling?
I haven't noticed that other than the one thing you pointed out.
Well, we have cameras. That's what the cameras are for.
Let's refocus our attention on what we're here for, and that's this trial.
I'll take that.
Do you have anything you want to put on the record?
I'm putting it on the record if I get a chance.
No, you need to let me finish. As it relates to the video and my decision to admit it.
She just admitted that she just now came with the exhibit. It was not that she just said. She just made it an exhibit. It was not an exhibit before she made it one.
So do you have some legal basis, sir, for your position?
What do I need legal basis for when she just admitted on the record that she just made this exhibit up
No,
right
she
now.
didn't. That is a complete mischaracterization. Sure, she did not.
That's what. So she wasn't
Create
implying that by
the
saying that she
exhibit.
could
She did
pull
not make it
anything
up.
out of her suitcase.
So that's a figure of speech.
Okay, so what is it
Right.
implying to? What would that be implying to?
As attorney,
How would anyone?
all right,
How would
I'm
anyone in
moving
my
on
position?
because you're not
How
providing me
would-
with any
how would
legal
any-
basis.
I didn't even
for
finish.
me to-
You told me that I can make the record. I'm intending to make the record.
Sir, as it relates to the video and my decision to admit it, do you
I
have
just said
anything?
that you didn't even let me finish.
You're not letting me
You
finish.
didn't let me finish either, Your Honor.
Because you're not providing me.
But how do you know I
You're
wouldn't get to
providing
that if I
commentary.
didn't finish?
You're not providing me with anything from a legal basis for which I would consider changing my mind. So the state's withdrawn their request to play the audio.
Then why play the video at all then?
I've already made a ruling on that. You're questioning the ruling. You're not asking me to reconsider it based on any legal basis.
There should be a legal reconsideration of it.
Then you need to provide me with the legal basis for that, sir.
So I'm supposed to just come off that with off the top of my head?
Yes.
That's ridiculous.
You're representing yourself. It's not ridiculous.
It is ridiculous. So I was supposed to already come in here this morning and say, oh, a video is going to be shown off the fly at the drop of a hat. Let me try to find some legal thing to combat. How am I supposed to do that?
The bottom line is you open the door to the playing of that video.
We're not talking about
And the
opening
video
no
was
doors.
previously provided to you during
We're
discovery.
not talking
There's
about opening no doors. We're talking about being fair.
There's
Because
absolutely
if I
no
would've did
prejudice
that,
to
Your
you
Honor,
in
with all
terms
due
of
respect,
surprise.
with
by
all
the
due respect,
exhibit.
if I had
Right.
done that,
I am going to move on.
if
from
I
this
had done
topic.
that, it would have
Mr.
been a
Brooks,
big
I'm
thing.
advising you.
Are you asking me?
I'm advising you, sir.
Oh, okay.
I'm advising you to sit down and
I don't
be
know what that
quiet.
means.
And if you interrupt me again, you are on notice that you will forfeit your right to be present
So
in
you're
this
holding me
trial.
in contempt
Mr.
for the
Brooks,
entire trial? Did you say the entire trial?
I never said any such
You said
thing.
for the trial. So what do
Please?
you mean? I'm asking, what do you mean?
Mr. Brooks, you continue to
That is
come at
not,
me.
I don't consent to being called
You
that name.
continue to fight with me.
I'm
You
not
are
fighting
being
with you.
disrespectful.
I'm not fighting with you. I'm not.
I'm
But
going to give you
said I
one
would have
last
the chance to make the
opportunity to
record.
sit down and be quiet so I can make a finding
Are you
as it
asking
relates
me
to
to
other
do
things.
that? Are you asking me
I don't
to
need
do
to
that?
ask, I'm telling you. Thank you. There were two other issues that came up that I advised the parties I would take up outside the presence of the jury and give, if appropriate, Mr. Brooks the opportunity to ask further questions of Detective Casey. There was questioning by Mr. Brooks about possible testimony and why it had to do with it was in the context of him questioning Detective Casey about speaking with Dawn Woods, his mother, and about a time in August, and there was some reference to his niece and nephew. And I sustained the objection. I wanted to take it up outside the presence of the jury. That's the first issue. The second issue was the questioning of Detective Casey by Mr. Brooks related to the jail search. Do you want the opportunity to question Detective Casey about either one of these two topics, is my first question.
Okay, why was it an issue with me bringing up
Mr. Brooks, I'm only going to ask you one more time, and if you don't
I'm saying,
answer
if I don't
correctly,
understand,
then I
if I
will
don't understand what was the problem in the get-go with the question, how am I supposed to answer it now?
Mr. Brooks, listen to me, please. I'm going to ask this question one more time.
Man,
It calls for
I
a
don't like,
yes or
I don't
no.
like your tone and the way you're talking to me. I don't.
Mr.
I don't
Brooks,
appreciate it.
Sit down. I don't care if you don't like my
I'm
tone.
not gonna-
You've
I'm
been
not gonna
pushing
sit
my
down.
buttons all day throughout this entire
Okay, you've been
trial, and
pushing
I
my
have
buttons
showed
too?
the utmost of respect
No,
for
you
you,
haven't.
and I don't
Absolutely
appreciate
not.
you impugning the integrity of this court.
If that's
I
what you want to
don't.
call it, that's fine, but it's not
Stop
accurate.
talking.
What you mean, stop talking?
I need to make a ruling. Okay,
Well,
I'm
let's-
purposely
let's
not
talk-
putting
let's
you in
talk
the
to-
other courtroom
Let's
right
talk to
now.
each other like adults then.
Mr.
Because
Brooks,
I've never told you to stop talking.
I'm going to ask this question one more time, and if he doesn't answer it, I'll take it as a no. Do you want the opportunity to question Detective Casey regarding either his questioning or meeting up with your mom and your niece and nephew about possible testimony, or the search of your jail cell? Yes or no?
What was the problem with me asking the
All
question
right,
about
he's
the
not
jail
answering
cell?
my question. We'll move on.
I'm trying to understand. If I don't understand, how do I know?
Recess, 15 minutes
How do
from
I
now.
know what I'm supposed to answer if I don't understand? And I don't agree to a stop.
Good morning, everyone. I will get started. I will call State of Wisconsin versus Darrell Brooks, case number 21 CF 1848. May I have the appearances, please?
Good morning, Judge Sue Upper, Leslie Basie, and Zach Witchow appearing for the State of Wisconsin.
Good morning. Good morning, sir. Please state your name for the record.
I'm here as a third-party intervener in that matter, appearing as authorized representative for my client. I accept for value and return for value all of the charging instruments in this matter and make my exemption available for discharge of all obligations and charges connected with this case. I do not dispute any other facts in the charging instruments.
Record should reflect that the individual known to this court as Darrell Brooks is present in person in custody in street clothing, wearing a suit and tie and a mask.
For the record,
today.
I did not consent to being called that name, Your Honor.
All right,
And we still have yet to address subject matter jurisdiction.
The court has
For the
addressed
record.
it for the record. So we
For the
will be,
record, has it been proven?
Mr. Brooks, I stand by the written decision that I issued in this case last week. A second
What written
copy was
decision are you
provided. Please
referring
don't
to?
interrupt me. A second copy was provided to you. I know you saw it because you tore it up yesterday. So I'm not going to address it any further.
Are you
You are
talking about
mistaken and wrong about the law that it needs to be verified or proven.
Are you talking about the paper I accepted in return for value?
So with
Accepted
that,
for value in
I
return for
believe,
value?
Mr. Brooks, I'm going to continue with this trial, whether you believe jurisdiction has been proven or
It has not been proven for the record.
And it has. So
It has
with
not.
that, Detective Carpenter was on the stand,
And it needs to be proven
and I
per the prosecution.
would like to have him brought back up unless there's any other issues the parties wish the court to address from the state.
I did want to address something briefly.
Go ahead.
As the court knows from our short discussions yesterday, the state will be playing a couple videos of the defendants and his statements. The court had previously heard those as part of a motion hearing, and I'm not sure if I'm really giving the defendant notice or what I'm doing, but I really tried hard, and I'm pulling out snippets from this because if the court recalls, there are a lot of references that the defendant makes to prior domestics with Erica, his prior record, things that the court had previously excluded. So I'm going through and I am pulling specific time ranges from this so that nothing that was previously ruled inadmissible comes in. And I guess obviously this defendant has the absolute right to cross-examine the witness. He has the right, and we've offered and we have been putting exhibits up for him. But I do want it to be noted that I would not be willing to have Mr. Brooks just say, oh, go to about the 7-minute mark, because if he even goes like 2 seconds before a clip that I had played or 2 seconds after, it could include information that was previously ruled inadmissible. And I guess what I would say to the defendant is the court has previously protected the defendant to make sure that things didn't come out. Where he asked a question that could be construed as opening the door, and the court said, we're not going to go there, Mr. Brooks, and he got the message. However, with this, if there's any portion of this video that's played that talks about the prior with Erica, I do consider that he has opened the door, and I will be asking the witness about it. So I guess this is maybe more so directed at Mr. Brooks, that if he plays clips that contain that information, he will have opened the door. He's had this video for weeks at least. These videos have been subject to a motion hearing. I'm not sure exactly what access he had to them before. I've reviewed the 5-hour video a number of times. I've been very meticulous in my timestamps that I'm grabbing out from here. And I am unwilling to have the defendant put Ms. Gussie in a spot where he's kind of, well, around this point. He needs to give exact times that he wants started and stopped, because what happens is if he says, okay, can you pause here, by the time he says that, 5 seconds may have gone by, which may be enough to, some of these, if I would play 2 more seconds than what I have here, it would open the door. So I just want the defendant to realize that this is kind of a slippery slope here, and he proceeds at his own risk. And I'm not going to ask Ms. Gussie to stop it at a certain time because I think something's about to be said. That's on the defendants. And if he opens the door, I can assure you, I will go into it. So I did want to put that on the record, Judge, not to be a jerk about it, but just once it's out there, I can't not address it. And if it's the defendant who brings it out there into the view of the jury, then I'm going to feel compelled to address it. And then I didn't know if the court wanted to go through the preliminary instruction that you had provided previously on the interpreter. My understanding is that Mr. Marquez speaks very little English. If you want to add the added paragraph, that would be fine for the state. I've had 2 discussions with him, and I would not say he is, that English is a comfortable language for him.
All right, thank you. As to the first part, to what the state brings up regarding the redacted recording, I would remind Mr. Brooks the court did enter some rulings previously. Why do you have to roll your eyes at me? Let's start the morning off on a good note,
I didn't
sir.
roll my eyes at you, so I don't think it's fair that you should say I rolled my eyes at you.
I saw you roll your eyes at me. I'm not
I
going to
didn't roll
debate
my
about
eyes at you, so don't do that.
Well, Mr. Brooks, I'd appreciate a little bit more respect. These
I would
rulings,
too, Your Honor.
let me finish, because now you're interrupting me. These rulings were entered by the court to prevent other acts evidence from coming in, but a defendant can open the door in a variety of ways. These recordings, and I have reviewed them previously, do contain discussion and statements by you regarding these other acts. And as you heard from Attorney Basie, she has all of the timestamps to stop at appropriate times so that the state does not run afoul of those pretrial rulings. You can open the door by asking questions, by asking for a video to be played, and not knowing those exact timestamps. I think it's important that I reinforce what the state has just advised you of, so that when you are watching the recording, as all of us will be, if there is something you want replayed and you want to cross-examine the witness about, that you know those time stamps, and then the state has graciously indicated they would assist once again in replaying portions of that video. I don't need a response from you unless you feel you would like to give a response to any of that.
With all due respect, they're the ones that want to play the video, so I don't understand how I'm the one opening the door. They chose to play the video, so
they're not going to play the entire video, though. They're going to redact out, probably stop, fast forward the portions that this court said would be inadmissible. So for example, if during your cross-examination of Detective Carpenter, you ask the state to replay a portion of the video and you say, go back to around the 7-minute mark, you have to understand that you may open the door, even inadvertently, to some of those other acts evidence coming in. So what I'm telling you is, if you want any portions replayed, then, or if you ask for the entire video to be played under the rule of completeness, that you have an understanding that you would be opening the door to the evidence of other acts coming in. Potentially, I'll have to rule on it at that time. But So be mindful of the timestamps.
I don't understand, and Your Honor, that's almost like you making a ruling and then it not having any standing. If you already made a
the
ruling.
ruling's against them. I told the state they can't offer this evidence.
Right,
They're
that's
the
what
one.
I'm saying.
So if you offer the evidence or ask questions that would open the door, that's a different story. And we all have treaded lightly when you've asked questions that would have opened the door to a variety of witnesses. So the state's just simply saying, look, we're going to do our job. We're not going to put in the other act's evidence. We're going to pause the video, fast forward the appropriate spots. But if you want any portions replayed, or if you ask for the entire video to be played, then you do that at your peril of having those other acts' evidence come in. So that's all I want to tell you. As far as the jury instruction, do you have any position on whether that second, well, I shouldn't say second, it's the very last paragraph where it says, add the following if appropriate. Do you have any position on whether the court reads this entire jury instruction 60 to the jury prior to Mr. Marquez being called as a witness?
Yeah, I think the jury should hear whatever needs that they need to hear.
Do you have a position on that last paragraph specifically, sir, given the information that the state has provided today?
Last paragraph.
It's in brackets and it's after a bolded section that says, add the following if appropriate. I advised the parties yesterday we would be talking about that this morning.
I mean, it was just stated that the witness doesn't speak very good English, and so that would indicate that it would be a lot more work for the interpreter to make sure.
That's not what I'm asking about, sir. I'm asking whether you have a position on whether I include the very last paragraph of that instruction to the jury.
No, I don't feel like that needs to be read to the jury. I think it's pretty clear from all the language leading up to that.
Let me ask Attorney Basie a question about the contact the Office of the District Attorney has had with Mr. Marquez. Were you able to communicate at all in any way in English, even if you would describe it as broken English?
Yes, I think our last conversation, we probably said, I said something in English, he responded, and then when I said something else, I think he needed translation for that. His primary, our victim witness person, specialist assigned to the case, is bilingual and she speaks to him in Spanish.
All right, given that bit of information provided by the DAs and Office of the Court regarding his ability to answer some but not most, I think it's appropriate to read the very last paragraph. Certainly doesn't hurt. It's not going to take away. So I will read the entirety of jury instruction 60. Obviously the part that says read here if appropriate comes out, and then I will print that off, and that is what I will read at the appropriate time. Did that print, Madam Clerk?
Quick question on that. How do we know exactly what words the witness will be able to understand in English versus?
That's not how the interpretation works. The questions are in English, they're interpreted in Spanish to the witness. The witness will answer, presumably in Spanish, and then the witness's words will be interpreted in English, and it's the English, as this instruction says, that is the evidence.
I think it's a little unfair that prosecution has had conversations with the witness and I haven't, considering that it's my witness.
They were on the state's witness list as well, I believe. So it's fair for either party to reach out, and if witnesses want to talk to either party in preparation, that's frankly fair game.
So how would I be able to reach out to a witness?
Mr. Brooks, you are representing yourself. That obviously poses some challenges and difficulties, but that is the state and stage that we are at. So with that, I know we'll get Detective Carpenter on the stand. He can come up and be out here when the jury comes out. So come on up, sir. I will swear you in again, as is my practice when there's a witness on the stand for a second day.
I have one more thing real quick.
Well, it needs to be other than subject matter jurisdiction, so what is it?
You didn't even let me get to it.
I said, what is it? I said it needs to be something other than subject matter jurisdiction.
Can I
What
get
is
to it?
You can say.
There's no way to know what I'm going to say if I can't say it.
Mr. Brooks, please tell me what it is you'd like to address.
I want to address why my ICFs have not been addressed, because I know you have them. Why have I not getting copies? I've gotten copies of every other ICF. Why not the recent ones?
Sir, I am not going to be the intermediary anymore for ICFs that are directed to the clerk of court regarding copies.
That's not explaining why I haven't.
I'm not
even
the
been
keeper of
told
the
if
record.
they've
So if there's
been
something
received.
you want me to address, then you should address your ICF to me and not the clerk of court.
Well, where is the ICF?
Sir,
if I sent it, I
I
should be
am
able to get a
not-
copy. I've gotten copies of every single one.
You need
whether
to
they were
ask
addressed,
for that from the clerk of
whether
court.
they were addressed to you or whether they were addressed to the clerk of courts. I've always
I'm not going to
been
address
told.
that further, Mr. Brooks. I'm not going to be the intermediary when
So
you
what's
have
the-
questions to the clerk of court.
So
for
what's the
copies
point of
and
me
things
sending the
like that.
ICF, me doing what you asked me to do, and sending them, and then not being able to know if they've even been received and get a copy of them, which I've been getting
If
copies
you
of
did
them
not
ever
ask
since.
for a copy of the ICF, they don't have any obligation to
I
send it.
addressed it when I first sent it. I asked you on the record, did you receive it?
Mr. Brooks,
You said-
I didn't receive anything because nothing has been sent to me.
Well,
So
where's the
if there's
ICF?
something that you need, then you should reach back out to the clerk of
I
court.
shouldn't have to do
But we're
that
not
if I
going to
sent
take
it.
up court time regarding an ICF sent to the clerk of court. Again, I will advise you once again, I did this the other day, if there's something case related, it needs to be addressed to me. If it has to do with the record, it needs to go to the clerk of court.
And it was.
Because I
It was
am
sent to the
not
clerk of court.
the
But I still should be.
custodian.
I still should be able to be told if it was received and get a copy, which you've done that before every single ICF.
And I told you I
So why
would
does
no
it change?
longer be doing that, sir, because of this very issue. It
So you
takes
saying
up
so
court
now it
time.
changes? So now it changes all of a sudden?
No, it didn't change all of a sudden, sir, and you know that, so don't try to confuse the
Does it
record.
change all of a suddenly? Because
No,
I've been getting copies of everything I've sent, which is what you asked me to
This
do.
changed last week, and you
It
know
should.
that.
It shouldn't change.
So
No, I
with
don't
that,
know it.
I'm bringing the jury out, and I'm not addressing this issue,
So
sir.
I
We're
want the
gonna
copy of
continue
my
forward.
ICFs that I send.
Send the request to the
I don't
clerk's
have to
office.
send her another request. Where's the one that I just sent last week?
All right, the jury is going to come out, so please be respectful.
I will, but at the same time, you still have to. I did what you asked me to do. If you tell me to do something and I do it, and then now you're saying I'm not going to get a copy, which you've been providing them ever since you told me to do it.
Mr. Brooks, the rules on that changed last week.
No, it did not. I'm still supposed to be able to say if it's been received or not. So why should I have to send multiple ICFs to even know if they've been received? That's ridiculous, Your
I'm
Honor.
going to give the parties the final version of jury instruction 60, which I will be reading at the
That's-
appropriate time.
Come on, you can't change stuff at the last minute. You
No,
asked me to
Mr.
do
Brooks, I
something.
did it as a courtesy,
You
and
act-
frankly,
No.
you're not courteous
I'm not.
to me.
I'm not
So
even.
the
I'm
jury's
not even.
coming out.
I'm not even
The
referring
record
to
should
that.
reflect that the
I'm
jury
referring
is
to the
coming
fact. I'm
out.
referring to the fact that you haven't even
Mr.
had enough
Brooks,
respect to tell
please
me
be
it's been
respectful
received.
to the jury. They're coming out.
Okay, that doesn't mean that you shouldn't be able to tell me if my ICF has been received. ICFs that you told me to submit. You told me that.
Ladies and gentlemen of the jury, you will disregard the commentary by Mr.
I
Brooks
accept for
at this
value in
point.
return for value this document. Just like you've been hiding everything from the jury that they
The
need to
jury
hear.
will disregard. The court is not hiding anything from the jury.
Yeah, you are.
So,
Yeah, you
Mr.
are.
Brooks, please be respectful of the jury. They're
And
coming out.
You should be respectful
We
of
are,
what you asked
you are
me to do.
addressing issues that are not related to evidence
They
in
are.
this case.
You asked me to do
Mr.
something,
Brooks,
I do it,
please.
and
All
then
right.
now it changes.
Everyone can be seated. Thank you.
This is ridiculous.
Just like subject matter jurisdiction hasn't been proved. Just like you're making judicial determinations that you don't have to prove anything by law.
Hold on.
Which is a tacit agreement by you, Your Honor.
Ladies and gentlemen of the jury, please disregard the statements currently
Why? 'Cause
being
it's
made
true?
by Mr. Brooks.
Why? 'Cause
They are
it's true?
Incorrect statements of the law. They
Then
are
prove
not
that they're
evidence.
incorrect. Prove.
In this case.
Where's the proof? Where's the legal proof?
And you need to disregard them.
Because you don't have it.
And we are
Don't
going
have
to
legal
continue
proof.
with testimony, Mr. Brooks. I warn you,
I don't-
do not interrupt.
I don't
or
identify by
We will
that
have a
name.
discussion about whether you will continue to be here.
I don't
All right.
consent to being called that name for the record.
Detective Carpenter, please stand, as is my practice when a witness is on the stand for a second day to be sworn in again. Go ahead, Teresa. Please raise your right
Lie
hand.
to the jury.
Do you solemnly Go ahead.
I apologize. May I ask the court to consider perhaps an alternative, and I fully respect the ruling the court has just made, and I understand the basis for it. We all know the defendant, in his petulance, will say jury nullification in the first 3 seconds the jury's in the room.
Objection to that.
Proper
I don't
thing
think
to
that
do,
I
I
should be
think,
talked
Your
down
Honor.
Stop interrupting
I don't
Attorney
think I
Hopper,
should be
please.
talked down to.
Allow him to make his closing argument. I will object if he misstates the law. You can instruct the jury to disregard any misstatements of the law. And we continue in that fashion, if possible, for a reasonable amount of time. And if it becomes to the point where there's no reasonable, legal, credible argument that's being made, then the court can decide as to whether or not he's forfeited his right to a closing argument. But we could at least try to, by merely objecting and the court telling the jury to disregard and instructing Mr. Brooks to move on to the next topic, we could try to allow him his opportunity to provide a closing argument. If that's unworkable, then I think this record will be very clear as to the efforts of this court. And I think there is materials in the bench book, or I'm sorry, the jury instruction 705 that talk about a jury instruction. This court could even give, telling the jury that they are not at liberty to disregard the law, but we're not going that far yet because, frankly, you have told them and you will tell them that closing arguments are not evidence. And I think they will abide by that. So I know it's going to require effort for the court to allow this to allow Mr. Brooks to try and proceed, but I think we should try that or something similar to that in an effort to get through this next step, or else we will continue at this pace forever.
I'm certainly willing to try that.
It's about all we could come up with, Your Honor.
I mean, I'm certainly willing to try it in this courtroom, and if he disregards that, to excuse the jury and then have him present from the other courtroom would be the second step, and then third would be a forfeiture.
Agreed.
Your Honor, I object to that.
Your objection is noted for the record. That will be the course of action that this court takes. The first time you violate the rule, you may be subject to forfeiting your right to be present, where you will give the closing argument from the other courtroom. And if you continue in a blatant disregard of the requirement that you not reference in any way jury nullification, I may make that final determination outside the presence of the jury.
I object to that, Your Honor.
All right, with that, let's bring the jury
For
out.
the record, may I respectfully request the legal reconsideration of your ruling?
So is that a tacit agreement that you don't have to answer my objection, Your Honor?
I decline to reconsider.
I reject that ruling and take exception to that ruling, Your Honor.
Noted for the record.
For the record, may I request a legal or factual basis for your ruling, Your Honor?
Denied.
For the record, may I respectfully request a written judicial finding of facts and conclusion of law on this issue, Your Honor?
Denied.
For the record, may I respectfully move for interlocutory declaratory appeal on this matter?
I'm not the court to address that.
For the record, may I move to stay these proceedings until this instant matter is adjudicated by a court of competent jurisdiction, which this court has no subject matter jurisdiction.
Denied.
Under,
The jury's
based on
coming
what
in.
law or
All
fact?
rise for the jury, please.
Based on what law or fact? Because I'm going to inform the jury of their power. They deserve to know.
Okay. Thank you, sir. I don't have any other questions.
All right, sir. Mr. Brooks, do you have any questions for this witness?
Yes, I do, and I object to being called that name for the record. Do you recall giving a statement to Officer Probst?
I don't know his name, but I've talked to an officer.
And you did talk to an officer that night?
I talked to an officer on the phone. I did not talk to an officer that night. I mean, on the phone I did, but not in person.
So it was a conversation on the non-emergency line. Would that be fair to say?
It was on the non-emergency line. I actually confirmed it after I called to make sure I was on the non-emergency line.
Do you recall the description that you gave at that time?
I do. Well, my best of my knowledge was that you were either black, Latino,
who's you,
or mixed.
Who's you?
Hold on, you have to let him answer the question first before you interrupt him with another one. Go ahead with the description you provided that night.
I said that the individual was either black, mixed, or Latino.
So it would be fair to say you didn't know at the time?
I was giving a general description.
So it would be fair to say that you weren't sure?
I was positive it was you.
Who is you?
You. I'm looking at you.
And how did you come to that conclusion, the you conclusion?
I'm looking at you.
How did you come to that conclusion? Did you?
What conclusion? Can you restate the question?
You're saying that you gave a description on the non-emergency phone line, correct?
It was on a non-emergency line.
So it would be fair to say at that time you had no name or knowledge of who the person was in your backyard. Would that be fair to say?
I had no idea who you were.
And so how can you say how can you say you then if you had no idea?
I'm looking at you. You're the guy.
And how did you come to that conclusion?
You and I were standing in the same yard looking at each other.
So is it possible you saw something on the news?
No, I had no idea who you were.
Interesting. Do you recall giving a description of approximately 5'9" and 160 pounds?
Yeah, something like that.
Something like that, or would that be accurate?
I didn't have a tape measure out. It was just a guesstimate.
Would it be fair to say that since you keep identifying me as you, would it be fair to say that I'm not 5'9" nor 160 pounds?
You have your shoes on or off right now?
Would it be fair to say that I'm not 5'9", 160 pounds?
If you take your shoes off and step out of them, they could have a better.
I'm not going to have them do that, but if you're able to answer the question, do you agree?
I'd have to be standing next to him. That's what I made my judgment from. We were about 2 feet from each other.
Does it look like I'm 5'9"?
I don't know. We were a lot closer.
Does it look like I'm 160 pounds?
Objection.
Grounds.
It's irrelevant as to his appearance today, just like his hair isn't in dreadlocks today.
Sustained.
Objection.
Question.
Grounds for the sustain.
Hold on. All right, sir, I'm going to let you make an offer of proof as to why you believe the photographs and the questioning about contact after the alleged incident is relevant.
It's relevant because these were sent by the witness.
It assumes a fact, not an evidence, but
You
what
want
is...
the letter
Hold on. Tell me the basis you believe there's been communication and why you believe it's relevant to her testimony.
It's relevant because it was testified to her first time testifying, and then also by was the last guy, Guth?
Mr. Brooks, my name is Jason Peckloff, and I'm with the Catholic Community of Waukesha. I was one of the victims you hit with the SUV you were driving on November 21st. What you did to my Catholic community and to the city of Waukesha show that you had no regard for life. What makes it more disappointing that you have shown no remorse for what you have done. While you're sitting in prison, I want you to reflect what you have done. I want you to reflect that you nearly took my life. I almost lost the chance to see my wife and kids again. I may have never had the chance to love or hug them again. You intentionally harmed my community, whether it was physical or psychological. You stole our innocence that day. Before that tragedy you created, it was a beautiful day we all experienced and never thought an evil thing like this could ever happen at a parade. My friend, myself, and the Waukesha Catholic community were asking parishioners and their families to participate in this parade. Imagine the guilt we must all bear for the rest of our lives. Because of your actions, I was out of work for about 6 weeks. Then I had to go back part-time because of my sustained injuries. Because of your actions, the multiple lacerations you created leaked out of the bandages and onto my bed comforter and sheets. What an awful visual to have. Because of your actions, I could have lost my foot. Thank God my nurse friend was checking on me. Because of your actions, my wife cannot get the images out of her mind of what you have done. You have forever scarred her. Because of your actions, my wife had to hand over my children to our community friends to check on my lifeless body. Because of your actions, my children, 4 and 6 at the time, had to go with a grieving friend to find her own child that was in lockdown. It took a while for them to be reunited. Because of your actions, my children are scared to death when they had to cross the same street you drove down. They were bawling and begging me not to cross the street. Because of your actions, I need to reassure my children that it is safe at parades. Not sure they ever feel 100% safe. Because of your actions, not all people in our community are ready to go back to the parades. Again, you stole that innocence from them. Because of your actions, My children are scared of sirens. Because of your actions, they were scared of red SUVs every time they saw one. They cried and hid. Because of your actions, I walked into the entrance of my children's school and felt like a triage unit. I saw children on crutches and a walker. What an awful image to be burned into my memory. Because of your actions, I feel terrible. I could not help my community and the city by testifying during the trial. Your cowardly actions did this. Your actions forced my family to seek out therapy and resolve in their minds what happened. Your actions made us second guess what we did that day. What could we have done differently? During this trial, you show no remorse. It makes you look like a monster. During the trial, you show little regard and respect to the court. It makes you look disrespectful. During the trial, you treated multiple witnesses terribly. You were trying to twist the words of our pastor, who is a man of the cloth. You made a comment to a witness you injured that he was walking fine now. It makes you a callous jerk. Despite what you have done to my community, I forgive you. Forgiveness does not remove the need for justice. Justice must be served and you must go to prison. My prayer is that forgiveness will heal your wounds and the wounds for the city. Thank you.
Thank you, sir.
On November 21st, you killed my mother. And in this courtroom, I watched you run her down and her broken body slide across the concrete. This woman loved and she was loved. You ran her down like she was nothing. And since that day, you have shown no remorse. You'd offered no explanation for your atrocities. It offends me that you're sitting here breathing while she is not. You are a monster. You deserve contempt and death. Sadly, with no death penalty in this state, I can only hope they lock you away someplace so deep the rats chew on your fingers at night. As for me, this will never be over until the day I'm pissing on your grave. I think it would be fair to say that for your crimes, even God hates you.
If you could just tell me, go ahead.
Yeah, for the record, Your Honor, that was the son of victim
2.
B.
If I could first thank the court, you, Your Honor, and your staff for getting us here today. I don't know how you did. You kept us under 4 weeks, and this is all going to be wrapped up, before the first anniversary, and that means a lot. So I thank you for that. And if I could thank everybody at the prosecution table, our real-life Avengers. I mean, you guys did everything you could for us, and I'm forever grateful. Thank you. And I couldn't not thank Jen Dunn and her staff. I mean, she took all of us, supported us, made us into a family, and without them, I don't think I could have gotten through this trial. And Mr. Brooks, I hope as I read my statement, you continue to roll your eyes. I hope you continue to laugh and just show how bored and unmoved you are by all of this, because I think that's important. It's important for the world to see that evil can be a tangible, living, breathing thing. I think it's important for the world to see what human rot looks like. And to all the survivors, every time he puts his hand on that empty cavity where his heart should be, I hope you all smile, and I hope you take solace in the fact that today is our day. Today is for us. Today is so we can take our handful of dirt, throw it on his grave, and move on. Because that's what we all need, and that's what we deserve. My name is Chris Owen, and I am the plaintiff. I'm here on behalf of another plaintiff, my mother, Leanna Joy Owen. Lee Owen was a mother, a grandmother, a best friend, an apartment manager, and a dancing granny. The reason none of the witnesses saw her in this courtroom is because she was executed by a child-killing sex offender. And we are both injured parties. My whole family is an injured party. To my kids, Lee Owen was nanny. And nanny spoiled her grandkids every chance she got. On every birthday, she would call and sing happy birthday to their voicemail so they could hear it the first thing in the morning. She went on a tour of my son's summer camp. She danced in the same parades as my youngest daughter. She wanted my oldest daughter to use her car to learn how to drive so she could teach her like she taught me. And all of that has been ripped away. But the defendant's conscience is clear. To my dad, Lee Owen was the love of his life. They met when she was 16, and he taught her how to drive. From that point on, they stayed in each other's lives. And even though they divorced, she was still his best friend. They spent a lot of time together, and she was the only one who could get him out of the house. Now my dad has nightmares of her body flying through the air and shattering against concrete. But Mr. Brooks' conscience is clear. To my brother and I, Lee Owen was our mother. A mother who, even when she was struggling, was always there for us. She was supportive of us. She always told us how proud she was of us. Growing up, all my friends and my brother's friends knew they were welcomed at our house. When they were in trouble, having problems at home, or just had to get away, she always let them stay as long as they needed to. And for years, every time I came home from the Marine Corps, she got all those same friends together so I could see everybody and spend time with them. She was the one that made sure everyone got their Christmas list out on time. She made the best eggnog I ever had. And she made my grandma's mac and cheese whenever we were together. She recently renewed her passport so she could visit my wife and I in Turkey and travel the world with us. She also couldn't wait to visit Machu Picchu with my brother. It was her dream trip. Out of all the places in the world, that was the one place she had to visit before she died. And now the best we can do is lay her ashes there. But Darrell Brooks' conscience is clear. And I believe him. Out of everything he said in this courtroom, I believe that is the one truth he told. I mean, how else could he make a witness look at each of his battered friends that he ran over and ask, how do you know who this is? Throughout her life, Lee Owen was a hard-working woman. That's why when she found herself on hard times, she was able to overcome them. Even though it took years, she dug herself out of a deep financial hole so she could live the life she wanted, the life she deserved. And she was in the middle of doing just that on the evening of November 21st, 2021. And I know this is corny and cliche to say, but Lee Owen wasn't 71 years old. She was 71 years young. She was one of the most active people I knew. She just didn't have it in her to sit still. She always had to be moving or doing something, and this often involved people. She was very social and loved being around those she cared about, and people loved her back. She had a knack for making you feel good about yourself without even trying, because she always found the good in people. Even when it was to her detriment, it never dissuaded her from helping people any way she could, without judgment, without demand for repayment or feeling she was owed anything. She did it because she knew it was the right thing to do, and it made her feel good. She accepted people for who they were and made people feel good about themselves. That is what the world lost, and you have the audacity to tell this court that your conscience is clear. I'm sorry, Mr. Brooks. There's not a human with a soul on this planet who could snuff that light out, who could steal Lee Owen from this world and have a clear conscience. And that is why you hear the term monster. That is why you hear the term demon. You know, I saw you that day. It was just after you ran over the Catholics. I saw you hanging out of the window, looking back with a smile of satisfaction on your face, laughing at an inside joke that at the time I didn't get, the punchline escaping me. I didn't get it when my mom didn't respond to my texts. I didn't get it when she didn't answer my phone calls. I didn't get it the first couple hours my brother spent looking for her. I didn't get it until my wife sent me a video of you running over children in the parade. That's when I got the punchline. And it hit me like your red SUV, Mr. Brooks. I saw a pure, unrepentant evil in your face that day, and it disgusts me that you are allowed to exist. And I know the answer to the question that everyone keeps asking. I know why you did this. You did this simply because you were not in a cage. That is what I find mind-boggling. And how dare anyone say the system failed him? The system failed every one of us whose only mistake was to bring their families in the vicinity of Mr. Brooks. That poor excuse for a man should not have been on the streets. That is the failure, period. But enough about him. Because today is not about him. It's about us and what we lost. I lost my mom, Lee Owen. And I wasn't always a good son. I could be selfish sometimes. I could be mean. But no matter how angry or standoffish I got, she would bend over backwards for me, even when I didn't deserve it. And now I can never tell her I'm sorry. I can never tell her I should have been more grateful. I can never tell her how much I need her in my life. Yeah, shake your head. Shake your head. You know, because that is what you took from me. And there's nothing this court can do that would provide justice in my eyes. So all I ask is that you rot, and you rot slow.
My name is Sean Sorensen, Virginia Sorensen's oldest son. Without warning, on a joy-filled Sunday in November, our family and others were devastated by an unfathomable act of evil. My mother, Virginia Sorensen, Jenny, a loving and devoted grandmother to 6, mother to 3, sister to 3, and wife of 56 years to my father, and friend to countless others, was taken from us for no comprehensible reason. My mom didn't let her age of 79 slow her down, be it the dancing grannies, her horses, dogs, cats, chickens, travel, working as a medical records nurse, holiday get-togethers, the occasional brandy old-fashioned, and having sleepovers and movie parties with her grandchildren. She enjoyed the company of others and was always up for an adventure. She never tired of listening to her grandchildren's dreams and inspiring them to shoot for the stars. She was so proud of all 6 of them in this photo: Carter, Claire, Gabrielle, Savannah, Brooke, and Mackenzie. She was killed doing something she loved and enjoyed with the dancing grannies, and although we were denied the chance to be with her when she passed, we know she was surrounded by friends and a caring stranger who sought to save her life, so we find comfort that she not die alone. She was a compassionate person. She was always telling us, "God bless you," or "Angels watch over you." She will be missed with an aching emptiness in all our hearts. Judge Doro, thank you for overseeing this trial. You define excellence in your profession, and we are so grateful you were assigned to this case. Thank you to the 12 jurors of this strong community who carefully and unbiasedly listened to the evidence and brought back 76 guilty verdicts. Thank you, Sue Opper, Leslie Basie, Zach Witshaw, and the entire Waukesha District Attorney's team for ensuring Mr. Brooks would not escape the consequences of his despicable actions. Thank you, Detective Tom Casey, and the many law enforcement officers of Waukesha and other jurisdictions who investigated, collected evidence, and testified to ensure Dale Brooks will never be a free man. Detective Casey came to my dad's house in the early morning hours of November 22nd to deliver the heart-wrenching confirmation that my mother had passed, and he has greeted us every day in court since then. I want to thank the Victim Witness Program, Jen Dunn, her staff, and their best comfort dog, Pepper, for their kindness and constant comfort to all the families affected this past year. She and her office have been a rock for us to cling to when events have threatened to emotionally overwhelm us. I want to thank the Waukesha Women's Center for supporting Corey Runkle and Erica Patterson in their testimony against Mr. Brooks and his abuse, and the good that the center does for other abused women. I want to thank the first responders and medical personnel at the parade who rendered aid to the injured and attempted to save my mother's life that night. And a nurse that we met at the memorial one night by chance, Sarah, who held my mother's hand that night. But she was already dead. A severed spine, multiple skull fractures, pelvic fractures, and her Christmas hat wedged under the windshield wipers of the Ford SUV. There was no ambulance ride or hospital stay. She was gone in a split second after Mr. Brooks smashed into her. But she will live on forever in our hearts. Finally, I would like to thank the Waukesha community and thousands of others for their outpouring of love and prayers to the families and victims of this unspeakable tragedy. I have few words for Mr. Brooks. Just saying that name brings anger and hatred into my heart. And I want to move forward after this sentencing with the happy memories I hold of my mother. I sat silently almost every day in this courtroom, bit my tongue, restrained myself from jumping over this divide to administer my thoughts of justice. As Mr. Brooks droned on about where the plaintiff was in this case, who the plaintiff was in this case. You've already heard, there are many plaintiffs here. I'm here, right now. I've been here all along. And now he gets to hear from me and will from many other plaintiffs before this day is over. He is simply a repulsive man who has shown zero remorse for his actions and depraved indifference to life. His fake tears in court were never for those harmed, but only for himself and the freedom he has lost. His narcissistic behavior, disgusting trial antics, and defiance to accept any accountability displays how truly unworthy he is of anyone's forgiveness. While we lost my mom instantly, I hope his 76 sentences pass in a slow, miserable, depressing existence as a reminder of the many lives he shattered. There are two others I hold culpable in my mother's murder. Dawn Woods, the mother who knew her son's felonious criminal history and penchant for violence, yet bailed him out of jail for $1,000 after he had assaulted Erica Patterson by running her over with Miss Woods' Ford Escape. She continued to allow him to drive it and enabled his violence and murders that Sunday afternoon. The other is John Chisholm, the Milwaukee County District Attorney, whose misguided and ill-conceived bail reform policies led a violent, multi-convicted felon back into our community and onto our streets while already out on bail from a previous violent felony. Mr. Chisholm disregarded his duty to keep the people of this community and state safe from repeat criminal offenders and allowed a career criminal to snuff out 6 innocent lives. He is a coward who hides from the accountability for his office's negligence. If he had a tiny, single sliver of integrity, he would resign. Not once has Mr. Chisholm said 3 simple words to these victims and families: I am sorry. At least Miss Woods in her many media interviews has the humanity and understanding to say those words to the families affected. 6 families have been bound together forever in grief. 6 families have lost loved ones who are cherished and can never be replaced, but forever remembered with love. 6 names I will now never forget: Jane, Jackson, Bill, Tammy, Lee, and Ginny. As my mom was fond of saying, angels watch over us. And I know now there are 6 more watching over us. Judge Doro, my request is simple: maximum terms of imprisonment, every single charge, life without parole for all 6 counts of intentional homicide.
Effect. Objection.
Overruled.
It's a feature of Ring. I didn't add that, yeah.
And to your knowledge, does that timestamp appear to be accurate?
Objection.
Overruled.
Speculative.
Yes, that is accurate.
For the record, the objection was overruled.
This is a 20-second clip. I'm going to ask that we play it once with audio.
Hey, I'm calling an Uber, and I'm supposed to be waiting for it over here, but I don't know when it's coming. Can you call it for me, please? I'm homeless.
Can we pull that back up just to look at the timestamp one more time? Thank you. And just for those of us with not the greatest eyesight, would you mind reading that timestamp on the bottom right hand at the beginning of this exhibit?
Objection, leading.
Overruled.
Yeah, it says November 21st, 2021, and the timestamp says 17:01, so 5:01 p.m.
Okay. The voice we heard in that exhibit that we just played, whose voice is that?
Objection, leading.
Overruled.
Objection.
You may answer, sir.
It's Mr. Brooks's voice.
It's not yours?
No.
Okay. Your Honor, I'd ask that Mr. Brooks please be instructed to remove his face mask momentarily.
Sir, would you please remove your face mask and face the witness?
Was that a question of...
The state's asked, sir, please remove your face mask and face the witness.
I'm confused. He made a statement about voice.
The question's been asked and answered. Please remove your mask.
What was the question?
Please remove your mask and face the witness.
Mr. Ryder, do you see the person depicted in exhibit number 75 in the courtroom today?
Yes.
Can you identify him for us by telling us where he's sitting and what he's wearing?
He's sitting at the table right there wearing a black suit.
Okay, we've got it up for the jurors. Let's play this once with audio. Do you see yourself in that video?
Yes.
What are you wearing in the video?
A gray shirt.
Overruled.
A gray shirt.
Did you hear the wind in that video?
Yes.
What do you recall being said in that portion of the video?
Objection, leading.
Overruled.
I'm walking Mr. Brooks outside of my house, and my neighbor, Greg, says, "Are you guys looking for that guy?" And I had no idea of anything at this point, and so I say, "I don't know. This might be him." You can hear that in the audio. I don't know if anybody was able to distinguish that, but that's what was said. And then Mr. Brooks says, "No, no, no." And then I say, "Can I have my phone, please?" And then after that, I say, "Can I have my jacket, please?"
Did he provide those items to you?
He did.
Okay. Can we put up for the jury, please, Exhibit 78? This is a 20-second clip. We will play it once with audio, please.
My ID! My ID!
Mr. Ryder, what happened during that video clip?
Objection, leading.
Overruled.
Mr. Brooks, or I should say the suspect, came to my door, asked to come back inside to look for his ID. I said, "No, I'll look for it. You stay out there." And I was looking underneath the couch and everywhere that he sat for his ID when I hear the police officers saying, "Put your hands up." And
did you ever find that person's ID?
No.
Did that person leave anything else inside of your house?
No.
Flip-flops, sweatshirt?
Objection leading.
Sustained as to the form of the question. Please rephrase that last question.
What, if anything else, did that suspect leave in your house?
I don't.
Objection leading.
Overruled. He may answer.
I didn't find anything left in my house.
Okay. Can we please show for the jury Exhibit 79? This is a 19-second clip. We will play it once with audio.
26, Minor Block Elizabeth, 126. Hey, do you know this guy? Absolutely not. Okay.
We've paused at 18 seconds. That's the police officer you were talking about?
Yeah.
Okay. Can you, just for the record, read for us the time and date stamp on the bottom right-hand corner here at the 18-second mark of exhibit number 79?
Yeah, it's November 21st, 2021, and the time is 17:12 and 59 seconds, so 5:12 p.m.
The video is a little bit blurry. Do you know where Mr. Brooks is at this point?
Objection leading, and I do not consent to being called that name.
Overruled. Objections noted. You may answer the question.
Yeah, the suspect is on the east side of my walkway, on the northeast side of my house, in my yard. If you see where those two police officer heads are, the suspect is on the grass right there.
That's all I have for this witness. Thank you.
All right. Any cross?
Yes. Just one second.
Whenever you're ready.
Okay.
Will you be needing any of those videos put back up at any time?
Not that I can think of at the moment.
Thank you.
My name is Taylor Kulik. Standing next to me is my oldest son, Robert. I am the oldest daughter of my mother, Jane Kulik, and it is on her behalf that I will be making a statement today, as she's unable to speak for herself. November 21st, 2021, the day my life was forever changed. The day my mom was murdered. It's still hard to believe that my mom was killed while marching in a Christmas parade. I will never forget that day. When I received the phone call stating that my mom had been hit, I rushed to the hospital to find her. Within minutes of arriving at Waukesha Memorial, people of all ages flooded into the ER. Many injured, many searching for their family members, just like we were. It was complete chaos. After 3 hours spent searching and waiting, finally, a nurse came and asked us to sit down. My heart sank. I listened as they told us how my mom was unconscious when she was loaded into the ambulance, that they tried to save her, but the damage was too severe for her to fight. She was dead upon arrival. She didn't even make it to the hospital. It hit me like a ton of bricks. My mom was just murdered. She was dead. I did not sleep at all that night. All I did was cry. I sobbed for the loss of my mother. I bawled for the pain of my children losing their grandmother. And I wept for the rest of my family as we had all just lost an absolute gem. Next picture, please. I still cry, even as we approach 1 year without her. This year of all the firsts without my mom has been difficult, to say the least. Every holiday, birthday, and monumental life moment. Each of those moments, another reminder that she's not here. She was known for giving cards on every occasion, and she showed up to everything she was invited to. She was always present because she genuinely cared. You could tell by the way her smile lit up the room or how contagious her laughter was. Her presence alone was just a sense of comfort, a feeling of home. She was supportive, encouraging, and just so laid back that you couldn't help but get along with her. These are just some of the reasons we all love and miss her so much. Next picture, please. Her name was Jane Kulik. Her sister called her Pain, so she was Auntie Pain to my cousins, and known only as Grandma to my kids. But for me, her name was Mom. Mom and I were super tight. I could talk to her about anything in the world. We used to text each other almost every day, talk on the phone almost at least once a week, and go out to lunch, just her and I, every other week. Every day, I'm missing those text messages. I miss hearing her voice on the phone and receiving her adorable voicemails or seeing her face light up when I unexpectedly pop up at the house. To simply say I miss my mom is a dramatic understatement of my true feelings. I'm devastated, a bit lost, and I can't fully describe how it feels other than a piece of me is missing. My smile is not so bright. I don't laugh the same anymore because I'm just not the same. I have never experienced such a painful level of sadness for so many consecutive days. I have never felt this level of heartache for myself or for my kids. Even though we talk about it, I can only imagine how my kids have felt this past year. Not only are they coping with the loss of their own grandmother, but also they've had to watch me, their mom, grieve my mom. My oldest son is dreading his upcoming birthday, just like we all did this year, as it's his first in 15 years without her. My mom always said they had a special bond, and they really did. She had a unique bond with each of her grandkids, as she did with each of us. My other son, Darius, was worried that he would forget his grandma's voice. And my daughter, Kylie, is finally able to talk about her grandma without tearing up. Each of my kids had a super close relationship with their grandma, and they're all missing her deeply. We were all so close. From family game nights, barbecues, Sunday drives, to family vacations and beyond, we really did a lot together. We've tried to continue all these things without her, but they're different now. As the kids say, it's just not right without Grandma. Some things will never be the same without her. Everywhere we go, there seems to be exactly one empty chair that she should be seated in. A perfect amount of empty space in a family photo where she should be standing. Or a little moment of silence where she should be laughing or adding to the conversation. Empty space. That's what it feels like. Empty, broken, shattered. Our family has an empty space where one of our members belong. An irreplaceable person was taken away from us abruptly. A member of our family unexpectedly gone. The rest of us left with a broken heart, shattered by the murder of an incredible person, left with an empty space that only she could fill. You can go to the next one, please. At this time, I would like to address my mother's murderer. Whatever your name is, I don't care. You ran over my mom like she was mere roadkill. The only reason you hit the brakes that day was to get her off the hood of your car. You targeted her with your vehicle, and you hit her on purpose. You don't deserve to be here. You do not deserve forgiveness. You somehow still get to talk to your mom, but mine is gone forever because you killed her. It's astonishing to me that any person could have absolutely zero regard for their fellow human being. Since you call yourself a man of God, then you know that the only punishment you are deserving of is death 6 times over. And I can't wait for the day that I hear you're dead in prison. Thank you. I appreciate your time.
I'm David Sorensen, Virginia Sorensen's husband of 56 years, and I'm wearing this in this trial. Thank you to the jurors and those who testified who had to experience the horror of November 21st of last year all over again. Thank you, District Attorney Sue Upper, Leslie, Zach, and her excellent team. Thank you to Tom Casey, Waukesha Law Enforcement, first responders both on and off duty at the parade, medical personnel at the parade, and the area hospitals that cared for the injured. Thank you, Jan Dunn, and your caring team in the Victim Witness Office, especially my new furry friend, Pepper. Here's a thank you that nobody knows about. Thank you to J.J. Watt. He's a professional football player for the Arizona Cardinals, who gave this community money for funerals for the victims, 6 family funerals. Finally, thank you to the kind and compassionate people of Waukesha County, state of Wisconsin, and others from around the country and the world who have helped the victims of the Waukesha Christmas Parade find comfort, shared in their loss and sorrow, prayed for the injured, and offered words of caring so that we may heal both physically and mentally. Although I have very specific thoughts on how I and the parade families would want revenge on the convicted for what he did, I hand over his fate now to God. So I will let God determine the revenge I ask for, be it a week, a month, a year, a lifetime. I think it's fair to say the convicted is an evil animal, and I hope that God's wrath falls upon him. It actually started before the trial did, because he took away his own God-given name. He didn't want to be known by his name. I refuse to accept him as a person that deserves compassion or mercy. I too regret Wisconsin does not have the death penalty, because if someone ever deserved it, the convicted most certainly does. Life in prison is too kind. That Bible on your table will not do you any good for where you will end up. I have struggled this past year with Jenny's loss. It was to be her last parade. She was going to retire. I will continue to struggle with the loss. I am lucky to have family to care for me and wrap me in love so that I can start to glue together the shattered life I now have. I know Jenny probably saved our 2 granddaughters, who sit behind me, their lives by carrying the banner that day in their place, and I thank God for that. The life that Jenny and I built over 56 years of marriage was forever altered nearly a year ago. I will carry on in this new life with help from my family and friends. The life I was once able to share with Jenny is gone, but it has strengthened my family's closeness and in a way made us stronger for the great challenges we have ahead of us. I feel sorry she will not be able to hold a great-grandchild or see all of her grandchildren be successful in life, but I pray to her and know she is watching over us. My Christian faith and church have helped me cope with my sadness and find hope and love over hate. My friends have lifted me up in their prayers. My family carries my burden with me. My dogs at home give me a small measure of comfort when I am in need. Angels will watch over all of us and give us strength. Now I want you to use your imagination a little bit. When it thunders, I imagine that Jackson is blasting a home run over the fence. When there is a rainbow, I will imagine the dancing grannies, Jenny, Tammy, Lee, and Bill, with them dancing along its lines. When there's a ray of sunshine poking through the clouds, I will imagine it is Jane smiling down on us. When it snows like it did this morning, I will imagine God's love giving us a blanket and comfort. When I see a blue light, I see this community's commitment to help heal and support each other. Judge, you have witnessed the same evil I have. You have endured a very emotional and draining trial as I have. I ask for the full punishment within your power. I ask you to send this evil animal to life in prison with no chance for parole for the callous murder of my wife and 5 others and injuring 61 others. He should never have the opportunity to hurt another person and has forfeited his right to be a free man ever again by his violent actions against innocent lives, both young and old. You are a very evil, evil animal. Amen.
And Attorney Opper, you may provide the court with your sentencing recommendation.
Thank you, Judge. Obviously, I'm very grateful to the court for its patience in listening to all of these victims here today. It was very, very important that you hear from them directly, and the stories that they shared with you, really very personal and very compelling as to the impact that this crime had on so many people on so many levels.
Please.
Good afternoon. It's been a long day. First off, I'd just like to start by letting you guys know that it's a lot of information that you guys should be privy to, I believe. And one thing that I believe that you have not been privy to is the truth of your rights and your duties, being the jury. The fact that you and you alone have the power, not well-prepared DAs with well-prepared and clearly rehearsed speeches and exhibits and a lot of theatrics. Frankly, not the judge. You and you alone have the power. You and you alone decide what is truth and what isn't truth. You should be informed that you have the power to nullify any law that you don't agree with.
Objection. Move to strike the statement.
Sustain.
Objection.
I will strike from the record the last statement made by the defendant. The jury will disregard it.
Which is clearly what I've been saying. I believe that not only is it fair, but it's essential that you be privy to all knowledge, not knowledge that certain people feel that you should hear and shouldn't hear, disguised under the color of law. the fact of the matter is, just like I did with my opening statements, I don't have a well-prepared or rehearsed speech. I didn't look in the mirror and say certain points to myself over and over again to make sure I have them right or anything like that. I've chosen to speak from the heart in my opening statements, and now I'm going to speak from the heart. What you won't hear me do is argue facts. And the reason you won't hear me argue facts is because I believe that it takes away from what should be recognized. The tragedy of this event. It should be recognized. Trying to argue facts of this, facts of that, I'm not going to waste your time doing that. It's a little emotional. I apologize for the long pause. It's hard to keep everything together emotionally. And honestly, I don't believe that I have any more tears left. It's been a hard year. For the families, mostly. And that should not be lost on anyone. It shouldn't be taken away. I said it before and I'll say it again. It's a lot of people that are healing, that are attempting to heal. That opens the door to talk about forgiveness for a little bit. With every healing process, there comes a forgiving process. It's not an easy thing for anyone. What you've been hearing from the prosecution, and not to take anything away from them, but let's call it what it is. You've been hearing a lot of rerun. Same things over and over and over. No different than when you turn on the radio and you first hear that song that you don't like when you first hear it, but they play it so much that eventually you start saying it, the words to yourself before you even realize it. And then you sit and you go, I hate that song. Why am I singing it? That's what's been happening. Rerun. Over and over and over and over and over and over and over. Attempting to make things stick in your head that simply aren't true. Why do I say? What am I saying? I say, look at the testimony. You know, the theme from the prosecution here has been intent, 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 intent. We all know what's been said. We all know the picture that's been painted. Even the prosecution said themselves. How can you look in somebody's head and say, this is what they intended to do? You know, for a year, I've I've sat and gone through this. Feeling so powerless. You know, letting other people run with the narratives. Sitting back helpless while other people paint a picture that has zero truth. Zero. I understand about healing myself, tragedy, pain, all that. A lot of it, there's no need to get into. I myself in my own life have had to do a lot of healing. As a man with children myself. I find it hard to believe that anyone who's really had conversations with me, spent time around me, would think for 1 second that this is an intentional act. I've never heard of someone intentionally trying to hurt someone while attempting to blow their horn. While attempting to alert people of their presence. Which brings me to more information that I believe that you should have been privy to. And I'm sure that the prosecution will beg to differ. But the fact of the matter is, the vehicle in question, make and model of 2010 Ford Escape, the vehicle in question, actually 2008, 2009, and 2010 of that model was in fact recalled.
Objection, misstatement of the facts, facts not in evidence.
Was in fact-
Improper argument, Your Honor.
Sustained.
Was in fact recalled. Was in fact a class action lawsuit against Ford
Objection,
for those
facts not in
model
evidence,
for
Your
those
Honor.
model vehicles.
Sustained. The jury will disregard.
Information that you should have been privy to, that you weren't allowed to be privy to. Why? I don't know. That information, malfunctioning throttle bodies,
Mr. Brooks, move on.
it's information that you should have been privy to. Vehicles that malfunction and accelerate not being able to be stopped.
Objection, that is
It's
completely
information,
inaccurate,
it's
Your Honor.
information.
Objection. Hold on. Go ahead.
Move to strike statements by Mr.
Sorry for the
Brooks.
interruption.
They are facts not in evidence, Your Honor, and it's a complete misstatement.
Sustained. Strike
How's it a
the-
misstatement when I have the information?
Mr. Brooks, move on.
This is information that I feel like you needed to know. You should have known. Information that was taken away from you. Why? To prove a case? Information that you definitely should have been privy to.
DA says the defendant has an utter disregard for human life. Utter disregard for human life. Not realizing that they're talking about someone that has children. Talking about someone that watched their children come out of the womb and be born into this world, cut the umbilical cord, held them before their mom even did. Moments that I'll never forget. And yet they say disregard, utter disregard for human life. They made reference to a rage, as if they were, or if this particular DA was right there, standing right there, as if this DA is a psychiatrist. I said to myself, what rage? What do you mean rage? How can you characterize that? How can you have the audacity to diagnose what someone's brain is? Where it's at, what it's thinking, why it thinks the way it does. DA makes references to blocks of no one being injured, but then says it's intentional. You add that up with the supposed rage, the supposed intent to harm and kill, and it doesn't kick in until well within blocks. And maybe it's just me, but I would think if I was characterizing someone with this intent to kill and this rage and this anger, then why weren't people immediately harmed? Why would someone with intent to kill and rage try to alert people of their presence, repeatedly honk their horn? You heard a detective, if you recall, testify that the vehicle that he observed was not only honking his horn, but was not speeding. So where does this rage kick in? Where does this insatiable intent to kill kick in? They speak as someone who's known someone for years. Which brings me back to the vehicle. What if the vehicle couldn't stop because of the malfunction?
Objection, fact, not in evidence.
What if the driver of the vehicle was unable to stop the vehicle? Because of that fact, what if the driver may have panicked? Does that make the driver a crazed, or not crazed, a rage? Does that make the driver in a rage and intent on killing people? DA played exhibit 17. You don't see anyone struck in that vehicle. On that exhibit, you don't see anyone struck. Was someone who had this intent to kill, this rage, as she says. If that was their intent, wouldn't they have taken the opportunity to hit as many people as they could? Target people, mow down people. Reference was made to this vehicle, the damage. Says this was all caused by bodies, but then later turns around and says hits barricades and other objects. I've heard testimony about hearing loud crashes and things of that nature, but the DA wants you to believe that this all came from people. Evidence doesn't support that. So I go back to trying to wrap my head around everything that's happened in the last year. Praying for those families, praying for the people that tragically lost their life, because that should not be lost either. The fact that there was lives lost, and all the emphasis has been put on the alleged defendant, and the people have been disregarded. Makes me wonder, does the DA even care about those people? There's been prayers going up every day. It's been suffering on both sides. It's been threats, hate mail. Because of the narratives that's been put out there. The misconceptions that have been put out there. The lies that have been put out there. Lies that have caused my children not to be able to go to school. To be bullied. For my mother to have to leave her home and stay at a hotel because she's afraid for her safety. Because she gets hate mail shoved through her mailbox. My nieces and nephews to fear for their safety. And what's been equally hard is not only having to answer the questions from my daughter, who was 7 at the time, my baby girl, who was 7 at the time, is now 8. Attempting to answer her questions that she's asking, and still continue to shield her from what she sees, what she hears.
having a newborn son that I haven't even been able to meet. Haven't been able to hold, touch, kiss. Having to navigate everything that comes with this whole situation. While still attempting to wrap my head around it. I can't honestly say how many times I've sat in my cell, especially during lights out, alone, where it's just you. And just been praying and asking myself, how could this happen? Not just for the people, but for everybody involved, the community too. How could this happen? How? The hardest questions you can ask is those that don't have an answer. No matter how much thinking you do, no matter how much you try to look at it from different perspectives and listen to other outside perspectives and listen to people that you trust and that you love, still coming up with nothing. But to think for 1 second, one question I never had to ask was if this was intentional. That's something that I never asked once. Because I know it wasn't. As a matter of fact, it never even crossed my mind to even attempt to ask myself that, because I know it wasn't. And I know sometimes during this trial probably doesn't show. Maybe hard to believe. But trust me when I say no one outside of the families that had to go through this, no one's heart is more in pieces than mine. So again, I go back to all these exhibits. Go back to everything that's been shown, everything that's been testified to. Everything you've heard during this whole process, this trial. And again, I say the same thing that I said earlier. Same thing I said in opening statements. I'm not reading from any paper, any books. Everything you've heard in opening statements, everything you're hearing now is from right here. Everything. You have the decision. You and you alone, all of you, you have the decision. I'm sure you've taken a lot of notes during this process. Some days are longer than others. A lot of movement in and out of the courtroom for various reasons. Remember the power that you have. Don't for 1 second let it be taken away from you. I can never understand the position of sitting on a jury in something of this magnitude. So I'm sure there's a lot of pressure. I pray that the right decision is made. The right decision. It's almost like that a message, well, not message, but that writing when we're in our vehicles and we got that rearview mirror and it said things are closer than they appear. But it's also another way of saying sometimes things aren't as they appear. I can't speak for anyone else, but me, myself, I believe in Jesus Christ. That's how I was raised. That's what I believe in. None of us are perfect. But I try every day to make sure that I acknowledge Him. That's why every time I step in this courtroom, I have my Bible with me everywhere I go. I even read it on breaks, recesses. This is not something that started at the beginning of this incident. This is something that has been instilled in me since I came out of the womb. This is how my family lives their life. This is how we was raised. For whatever mistakes that I myself have made in my life, I've made peace with God. Made peace. I'm happy to say that my conscience is clear. And because I believe, I trust him with my life. Nobody will never know why it was his will for this to happen. A lot of lives were changed that day, mine included. God's way is not our own. And no matter how much sometimes we want to question, we have to have faith. Look inside yourself. Look inside yourself and make the right decision. Look inside your heart. You have everything in your hands now. Everything. Do what's right. Do what's right. Don't let the smoke and mirrors take away your power. Don't let the theatrics take away your power. Each and every one of you has a decision. Was right. Make the right decision. hard to think about. My younger kids getting older and at some point having to explain everything to them. Kids don't stay kids forever. And nowadays, kids is frankly a lot smarter than we were when we was kids. I'll tell you that much. I got a letter the other day from my youngest daughter, and she's still learning cursive right now, so she's the best writer when it comes to cursive. She'd rather print. She said, "Dad," and this is from the letter, she said, "Dad, why are people saying all these mean things about you?" I haven't read the rest of that letter yet. The rest of that sentence said, "That's not the dad I know." Throughout this year, I've been called a lot of things. And to be fair, I am a lot of things. A murderer is not one of them. Never has been, never will be. So before I close my statements, I just want to say, open your hearts. Go inside yourself when making this decision. Have no fear. pray, and do what you know is right. What you know is right. Think about everything you've heard. Think about everything you haven't been privileged to hear. Think about the whole entire picture. And above everything, whatever you decide, make sure you yourself can live with it. Make sure you can live with it. That's the magnitude of the power that you have. Just like this tissue is in my hand, this is everything. You have everything. Be at peace with what you decide. Had no regrets. Don't let this decision weigh on you after it's over. Hopefully we got a lot of living ahead of us. Lord willing. Don't look back and kick yourself in the behind. It's been about 3 weeks with you, and it took a lot of courage and a lot of guts to pause your life for this. To put important things on hold, to basically stop your life. You should be commended for being able to sit up here with this amount of pressure. I want you guys to know that's not lost on me. I'm sure it's a lot. And you all should be commended because it took courage to do this. I don't know, but I would bet a lot of people wouldn't want to be sitting in your position right now. And you guys had the guts to do it. Thank you for that. Thank you for taking pretty much a month and setting it to the side for this. I know it's probably not proper, but you guys deserve a round of applause if you could get one. thank you guys sincerely, and I know, and I have faith and I trust that you guys know what's right. Ladies and gentlemen, I don't think it's fair to just say guys, but I believe in your heart you know what's right. Thank you.
Thank you, sir. Before I give the state an opportunity to present rebuttal, please stand for a minute. So please stand.
All right, and these were scenes from the Brooks trial. And very good audience. I'm glad that new people in the audience are interested in seeing these things as well. And over time, we'll play, which I think we did. Okay, Brooks was found guilty of all the charges and is in life in prison. He was given some sort of appeals, but nothing really went through, and he's going to basically be stuck there. Now, what we're going to be doing now is soon get ready for the garden stream that people are also, looking forward to. And so we're going to conclude this one and soon go over to the other one. And Falcon, glad that you're able to see us with us, and thank you, Angel, also for your commentary, and everyone watching, listening, lurking. All right, so at this point in time, this stream will end. Soon, very, 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 very soon, we'll go to the garden for those that are interested in that one. Right? And peace. Everybody have a good Easter weekend.